The Appellate Division, First Department is now in session. Good afternoon, everyone. The first order of business will be me calling the calendar. At this point, when you hear your case call, please identify yourself, and then I will confirm to you the time that has been allotted for your case. First case, People v. Christopher Rice, is submitted. Brand versus Colas is submitted. Ashley P. versus Jonathan G.
Richard Hirschfeld for appellant.
Karen Steinberg for respondent.
Laura Selecki, attorney for the child.
Right. We've allotted 5 and 2 for the appellant, 4 for the respondent, and 3 for the attorney for the child. Estrella versus Rex Realty.
Stephen Regal for appellant.
Tim Shapiro from the law firm of Baxter, Smith & Shapiro on behalf of the respondent.
Thank you. The time allotted is 5 and 2 for the appellant, 5 for the respondent. Franco versus Hyatt Corporation.
Tammy Harris for the appellant.
Judy Shaughnessy for the respondent.
We've allotted 5 and 2 for the appellant, 5 for the respondent. Gallegos versus Bridgeland Vestry.
Good morning, Your Honor. Good afternoon. Dana Heights for the appellant.
Good afternoon. Bolam Kim for the respondents.
Each party is allotted 3 minutes.
Thank you.
People versus Daquan Giles.
Matthew Bova for appellant.
Clara Salzberg for the respondent.
Time allotted is 8 and 2 for appellate, 8 for respondent. Schlamm Stone versus Tusi.
Patricia Stern for the appellant.
Good afternoon, Joshua Wurtzel for the respondent cross appellant.
The time allotted is 5 and 2 for appellant, 5 for respondent. Brown versus Filbert.
Jeffrey Aronwald for the appellant.
Martin Block for the respondent.
Each party is allotted 3 minutes.
Your Honor, would I be able to reserve one of my 3 minutes for rebuttal?
You want 2 and 1?
Yes.
Sure.
Thank you.
That's the appellant, Mr. Aronwald. You were just
Yes.
Thank you.
Thank you.
All right. People versus Adam Wallen-Tynowitz, submitted. Lehman versus EDM Lennox is submitted. Kostick versus New York State Division of Housing and Community Renewal.
Paul Gruber for the appellant.
Dawn Ivy Schindelman for respondent, New York State Division of Housing.
Right, the appellant is allotted 5 and 2, the respondent 5.
Thank you.
Patrolmen's Benevolent Association versus de Blasio.
Aaron Bloom for the City of New York and NYPD appellants.
Michael Bowie for the PBA.
You're each allotted 3 minutes.
Your Honor, could I reserve 1 minute for rebuttal?
That's Mr. Bowie?
Mr. Bloom.
Mr. Bloom, you're the appellant?
Yes.
You want 2 and 1?
Yes, please. Thank you.
I'll allot it to you, although I'm not sure you're really going to need it.
Thank you.
All right. Matter of Jonathan O. is submitted. Carnegie Hill versus City of New York.
Reed Super for the appellants.
Anna Gottlieb for respondent city.
Philip Carmel for Avalon Bay Communities.
Lawrence Bartolomucci for New York City Educational Construction Fund.
All right. I've allotted 7 and 3 for the appellant, 7 for the city respondent, 3 for the Avalon respondent. And my understanding is that the New York City Educational Department, Mr. Bartolomucci, you don't have any argument, you'll just be observing?
That is correct.
Okay.
Thank you.
Thank you. First Franklin versus Merchant.
Charles Jeanfro for First Franklin from McCullough-Reimer.
All right, there's no time requested for appellant, and so I'll mark that submitted, and I've given you 3 minutes for argument.
Thank you, Your Honor.
Ballard versus Sin City.
Michael K. O'Donnell of counsel for Paul H. Maloney, PC, for the appellants.
Stephen Harfinist for respondent, Sin City.
Sean Callahan for respondent, Emissary Security.
Right, the appellant has been allotted 5 and 2. Sin City gets 4 minutes to respond, and Emissary 3 minutes. DJR Communications versus 530 Park Residential.
Yes, good afternoon, Kevin Schlosser for the appellant, Your Honor.
Good afternoon, Norman Oates for respondent.
All right, and I've allotted 5 and 2 for the appellant, 5 for the respondent. Perugia versus 1440 Broadway.
Brian Isaac for the appellant.
Anthony Tagliagambi for the respondent.
All right, and I've allotted 5 and 2 for the appellant, 5 for the respondent. That concludes the call of the calendar. I do want to remind counsel, because we have a very heavy oral argument calendar today. I think, quite frankly, as everybody's gotten used to these virtual platforms, everybody's more comfortable in asking for oral argument. I do want to remind you that we have had your briefs and the records on appeal for some time, so we are familiar with your case, and I would urge you to make your arguments as efficiently as you possibly can for everybody's sake. All right, the first case that we're going to call is going to be Franco versus Hyatt Corporation. We're going to take that out of turn because Judge Mendez has recused himself, and Judge Gonzalez, Elizabeth Gonzalez, is being vouched in. Okay, I believe we can begin.
Thank you, Your Honor. Tammy Harris on behalf of the appellant, Anthony Franco. I'd like to address first the lower court's finding that Mr. Franco's allegations were raised and trivial. As the court is aware, Mr. Franco had alleged that he had interactions with a supervisor named Nicole, which went from her telling him that he was good looking and handsome upon hiring him to inviting him.
Let me ask you a question though. When did your client first tell Ms. Hall's supervisor about his complaints that he was being harassed?
We first alleged it in November of 2013. He also claims he alleged it in December and January as the romantic overtures became more aggressive. Specifically, Ms. Hall, at one point in a room alone with my client, said that she had tattoos on places on her body that would require her to undress. And on multiple occasions, she would offer my client to undress in front of him, which he declined. She would try and touch his hand and his face repeatedly, to which he said no. And it got to the point where at one point he said, when he rebuffed her sexual advances, she specifically said to him that she has the power and that if he continues to reject her, that she will see that he is fired from his stewardship position. So for a supervisor to expressly state to an employee that they are going to be fired for rebuffing romantic or sexual overtures where she's saying that he's handsome and she wants to get naked in front of him, touching him when he says no repeatedly. These are things that also
This is Justice Gonzalez.
Yes, Justice Gonzalez. Hi, how are you?
Hello, good morning. Good. What are you? Good day. Good afternoon. Didn't your client testify at deposition that no action was taken against him because of any complaints that he made?
Well, he said in his deposition that he made multiple complaints and that at one point on the 28th of January, they told him they were going to fire him. And he said,
yes, but then didn't he also say that he was not sorry, let me change that. Didn't he say that he was being forced to resign because of his injury?
No, one of the things that he actually alleged was that Ms. Hall went up to him when he returned from his injury and said, "I don't care if you're injured, I'm going to get rid of you anyway," which followed her threat that if he rejected her sexual advances, she was going to see that he was terminated.
Counsel,
and her statement to him,
can you give us a record citation for that particular threat?
I'm sorry, I don't have the actual page right in front of me. It would take me time to locate it. I apologize.
It's in your brief?
It's in my brief. It's cited in my brief. I would defer to the brief for the actual page. I apologize. I don't know it offhand.
And the allegations of complaints that he made, those were made to Ms. Geary?
They were made to Ms. Geary in November, December, and January, based on his deposition. That is correct. And as well as Ms. Hall, because she was his manager and he repeatedly told her no. So being that she is his supervisor, the complaints were also made to her, at which point she testified, threatened to fire him if he didn't acquiesce. And at one point he says that she actually took garbage and when he rebuffed her, threw it on the floor, told him to pick it up, that her reaction to being rebuffed was to essentially go around to all of the coworkers, badmouth him, say negative things, that he was not their superior, that they were not to take orders from him, they were not to listen to him. She outright told coworkers such as Danny, who at one point called my client a bitch. She told Danny that she was working to get him fired and basically created an environment where there was nothing but disrespect for Mr. Franco to make it hostile for him. And being that she was in a supervisory role, when she sets this kind of example that he's not to be listened to, he's to be treated poorly, what happened
Did any of the plaintiff's co-workers corroborate these allegations, counsel?
There was an email from the chef, which was mentioned. However, that email dealt with him taking out garbage instead of washing dishes. It did not. What's interesting about this point is that it didn't culminate in disciplinary notices. The disciplinary notices that are a part of the record were never shown.
I'm sorry, for clarification, you mean disciplinary notices to your client?
Yes, so correct. Disciplinary notices to my client were first produced 4 months after he was terminated or forced to resign during a hearing over workers' compensation, and 1 month after he brought this lawsuit. And Ms. Geary actually admitted that she never showed him those disciplinary notices before he was fired, that she herself drafted them, even though they were alleged to have been done by accusers. They were unsigned by any accusers, unsigned by Mr. Franco, and admittedly never shown to him. So that evidence was dubious at the very least, and even the workers.
Counselor, your time has elapsed. I'm going to ask you to wrap up your argument, yet you will have time on rebuttal.
Thank you. Just in terms of the retaliation claim, I would note that my client testified he made complaints in November.
You can address that on rebuttal. Your time is up. Okay. Thank you. We have a tight calendar today. All right, I'm being tough. Okay, Respondent.
Good afternoon, Your Honors. My name is Judy Shamitzi. I'm with Wilson Elster for the respondents. Let me cover maybe quickly first those record citations. With respect to his testimony that no retaliatory action was taken against him, that's page number 112 of the record. And the question was, did anybody take any action against you because you had complained about Nicole Hall? The answer, no. With respect to when the plaintiff first claims to have made complaints about Nicole Hall, he did say at his deposition that it was as early as November, but then submitted an errata sheet, which is at page 128 of the record, correcting that November testimony to December, which of course is the only thing that made sense in the timeline that he was narrating at his deposition. And in fact, the reality is, even in December, he did not make complaints. And when he did make complaints, it was at his termination.
How do we know that? How do we know that?
Well, I recognize that on this issue, there is a conflict between his testimony and Gary's, but I do think that it is telling that there is simply no documentation of anything short of that, but there are these other disciplinary issues that are documented. And in fact, there is the email from the chef that is documented, that does not post-date the termination hearing. Certainly it cannot be impeached. I think it's a stretch to impeach any of the documentation, but certainly the email from the chef who runs the kitchen to say that's it, he's got to go. And he clearly has just about had it with him. I think that email shows, and the response to that email shows, that he was not fired for any kind of retaliatory motive. He was fired because there had always been an issue about him refusing to understand that he was in fact not anybody's boss.
But the issue of notice may bear upon the question of whether he has an underlying claim for discrimination, harassment, and a hostile work environment, correct?
I'm sorry, I missed the beginning.
Doesn't it bear upon whether he has a claim for hostile work environment and harassment? Retaliation is something different.
There are two different things in the case, Your Honor. I agree. With respect to the severity of the treatment of which he complains, we heard quite a bit about Nicole Hall allegedly bad-mouthing the plaintiff to his coworkers by saying he's nobody's boss. The reality was he was nobody's boss, and that was the issue. That was the disciplinary issue. It was not a retaliatory or a hostile work environment issue. He was consistently.
Counsel, sorry, this is Justice Moulton. There was an investigation that took place after he was fired, correct?
Yes, Your Honor.
How long did that investigation take?
It was quick. There were only a few. It wasn't technically after he was fired. It was in the space in between. Sort of they paused the meeting and then they picked it up the next day. It was quick. There were only so many people to speak to, and most notably, Gary spoke to Manny, who has two roles here. On the one hand, he is one of the people who is independent of anything that Nicole Hall may have done. Is complaining about his job performance. And on the other hand, he is one of the people whom the plaintiff implicated as having been told to be harsher on the plaintiff by Ms. Hall. And then he says, no, that just didn't happen. So it was done quickly. That's not to say it wasn't done thoroughly, because Gary spoke to everybody who was in any way implicated in the plaintiff's story, and they all basically said, no, it didn't happen. We don't know what you're talking about. What did happen?
Was the plaintiff allowed to respond to after that investigation was made?
I'm sorry, Your Honor, I missed the beginning.
Was the plaintiff allowed to respond to what was allegedly found during the course of the investigation?
The plaintiff came back the next day to conclude his termination hearing. I don't even want to call it a separate meeting. It was a conclusion of the initial of his initial termination meeting, and he was terminated.
Was he confronted with the statements by his coworkers, and was he given a chance to respond?
I don't believe that he was confronted with the written statements. He was told that he would be terminated and that his allegations had not been substantiated. I want to return just for 1 second to this issue of whether it qualifies as a hostile work environment to tell people that.
Yes, counsel, I wanted to go in that direction precisely.
Yes, Your Honor.
So let's talk about the question to Ms. Hall about the tattoos and her alleged response. That if he wanted to see the tattoos, he could see her undressed. So would you consider that to be trivial, a petty slight or trivial inconvenience, so to say, petty language, trivial conduct, assuming that it was proved?
Assuming that it was true, I would consider that highly unprofessional. I would not consider that to rise to the level of the kinds of offenses that the city or the state human rights law is meant to address. And side note, her tattoo is on her ribcage. So I mean, I recognize it could be a more explicit.
That would not be a violation of the city human rights law, even.
I don't believe so, Your Honor. I believe that the comment may be inappropriate for a workplace, but I don't believe that it rises. And not only that, but the response to the plaintiff's alleged sort of rejection also does not rise to the kind of conduct that is meant to be regulated. So I certainly If that happened in any office, in any workplace, that would not be acceptable, I think, to any decent employer. And certainly there's no claim here that the Hyatt would approve of any kind of statement like that. We don't think it happened, but if it did, the reality is the comment is not appropriate, but the comment does not rise to the level that, and we do see it in some of the cases, sort of this back and forth of how bad does it have to be to cross that line. And certainly your honors will draw that line here. I don't think that a comment about a tattoo on a rib cage, even if it were made, rises to that level. And certainly telling others that he's not your boss, don't listen to him, that is misconstrued in the context of what is actually going on in the case, which is even.
Counselor, you're way over your time. We understand your arguments, so please just wrap it up.
My very last point is that is what he is legitimately being spoken to about, that he must not pull rank on people because he simply does not have it. And for those reasons, I ask your honors to affirm the order on appeal. Thank you.
Thank you. All right, rebuttal.
Thank you. Well, to the extent that he was actually terminated for, as she said, pulling rank on people, there would have been disciplinary notices that were actually issued and not produced for the first time 4 months after his termination. In terms of the New York City law, it's a very liberal standard. And all that really has to be shown is that Mr. Franco opposed discrimination, which he did in this case simply even by virtue of saying no when Ms. Hall tried to touch him, definitely did when he rejected her offer to undress and get naked to show tattoos on more than one occasion, at which point she told him she had the power and would fire him if he rejected her overtures. So clearly he satisfied element number 1 under New York City law to oppose the discrimination. And number 2, he only needs to show that he was deterred or that the conduct of the defendant was one which would deter him in order to satisfy both the retaliation and the hostile work environment. And in this case, clearly, her getting mad and threatening to fire him for rejecting his overtures, taking trash, dumping it on the floor, and telling him to clean it up, giving him double work assignments, bad-mouthing him to everybody, calling him old man, and making his life a living
So,
hell.
counsel, let's assume for the sake of argument that all of that was said and done. All right. Would you agree or disagree that there was a non-pretextual reason for his termination if, in fact, he was having superiority issues, for lack of a better word, with his coworkers?
I don't agree with that. I think that the main
I'm
reason.
asking. I'm not saying that that's my position.
Okay, I don't agree. I don't think there was a non-pretextual reason. I think that Ms. Hall called it with direct evidence when, per his testimony, she said, "You're rejecting me sexually, and the result is I'm going to see to it that you're going to get fired." And as he testified, she went to all the employees telling them she was going to see to it that he got fired. She tainted the work environment to make them despise him. They hated him because of her, because she went around making them hate him. But even assuming what you say is true, there's a mixed motive here. Clearly, even if there was an issue of the chef writing an email, there's still the issue of a mixed motive, and did discriminatory animus play a role in terminating this man? And there's a material issue of fact on that issue. Summary judgment should never have been granted. You have Mr. Franco claiming on the one hand he was expressly told, "You're getting fired for rebuffing me." And on the other hand, they're claiming, well, the chef didn't like him and it had nothing to do with Ms. Hall. That material issue of fact gets his case to a jury, and summary judgment should never have been granted under such circumstances, especially when the disciplinary notices in this case are so shady, produced 4 months late, not signed by anyone, and admittedly never shown to Mr. Franco before his termination.
Thank you. Thank you. All right, the next case is Ashley P. versus Jonathan G. You would get yourselves ready, and we'll wait for Judge Mendez to rejoin us.
Here I am.
But I believe that Judge Mendez has rejoined us. All right. So now we're going to hear on the Ashley P. Jonathan G. case. All right, let's hear from the appellant.
Good afternoon, Your Honors. Richard Hirschfeld for Appellant Ashley P. There are two issues which I would like to address this afternoon. One is whether appellant met her burden of proving that relocation was in fact in the best interest of the child, Junior. And the second is whether the revelation in the brief of the attorney for the child that the father actually consented to relocation after the decision was rendered should preclude him from arguing otherwise now.
Well, let's deal with the first thing first,
Yes.
because we are not going to address what's not in the record.
Okay.
Right, so I that's just a matter of appellate law. So I don't think you can make that argument here.
Understood.
All right, so let's spend time on the first one.
Okay, the court is well aware of the factors to be considered in a relocation application. And in this case, we submit that appellant checked all of the boxes. One is economic necessity. It is undisputed that appellant was living in a dangerous neighborhood in a studio apartment with her two young sons. It's undisputed because respondent put that in his affidavit in support of his application for custody. She was living.
These cases are always a balance, right?
I'm sorry?
They're a balancing act.
Yes,
These cases are a balancing act. So one of the things that I gathered from looking at the decision of the lower court, who had held a hearing on that she was very concerned about the fact that two things. One, that she thought that your client was otherwise interfering with his relationship with the child, and she weighted that pretty heavily. And she also was very concerned about the fact that your client had actually moved without telling the father, and that the continued the order that allowed her mother rather than her to have the child during what would otherwise be her parenting time, but she wasn't there. So why on balance, what on balance did the trial court do that was a mistake? What was the mistake there?
Well, there are several mistakes, Judge. In terms of the affirmative findings that appellant was somehow deceitful in relocating, appellant actually did everything appropriately. Did she relocate to Texas? Yes. Did she take her other son? Yes. Did she get a job and apartment there? Yes to all of that. Did she take Junior there? No, she didn't. She waited. She did everything that was proper. She asked the court, can I relocate Junior to Texas? The fact that she herself relocated, if she hadn't, then the argument from the other side would have been, well, all of this is speculative. We don't know if she can get a job. We don't know what the community is like down there. She took affirmative steps to establish herself in Texas and then said to the court, can I take Junior? Not taking Junior and then saying, hey, I'm gone. By the way, can I take him?
Well, I think you miss the point of what the lower court did, is that assuming that what you're saying is true, and I have no real reason in the record to say that she didn't have a better job in Texas and that it didn't provide certain benefits. One of the things that the court was concerned about is that having not told the respondent that instead of having, when she was supposed to have time with the child and could not exercise that time, instead of allowing the father, who was a co-parent, to be with the child, she had the child with her mother. Isn't that something that the court could have considered?
Absolutely, Judge. That is certainly something the court can consider. But my sense of it was more that the court was concerned about the relocation itself. But putting that aside, there are other reasons why the court's decision was defective. First off, there were instances of domestic violence. As the court is aware, that's a compulsory factor that the court must consider in any decision. The court ignored that in this decision. The court found that appellant's testimony by itself was insufficient to show that Junior's would have a better life in Texas. That's not the case. There are many cases cited in our brief where the applicant's testimony by itself was sufficient. If Respondent took issue with what appellant had to say about the community in Texas, her improved job prospects, anything. He was free to challenge it. He did not do that. But
didn't the child express an interest in staying with his father?
I believe so, Your Honor, but the child was of young age, and while that is
isn't it due some consideration?
Absolutely, absolutely. But I think you also have to consider, well, I take that back. Yes, absolutely, Judge. The child's interest is something to take into consideration. My point, though, is that the judge, in making its rulings and failing to deal with domestic violence and concluding that appellant's testimony was facially insufficient, the court basically erred as a matter of law. Another issue was the court's conclusion that respondent.
I'm going to ask you to wrap up your argument,
Yes.
Counselor, because you've already exceeded your time.
2 seconds. The court's conclusion that respondent was medically negligent. That's an attorney's 2 seconds, Judge. Medically negligent. In September 2018, Junior was in respondent's care, vomiting, high fever, asked what he should do. They told him take him to the emergency room. He didn't. The next day, the symptoms persisted. He asked what to do. Take him to the emergency room. He didn't. Finally, on the 3rd day, appellant's mother had to intervene to get him medical help. This is not the person who should have custody of Junior. Thank you.
Thank you. All right, we're going to hear from respondent.
Yes, thank you. Karen Steinberg, appearing for the respondent, Jonathan Gonzalez, who is the father of Junior, who is currently 6 years old and was 5 years old at the time of these proceedings. I'm mostly going to rest on my brief. I think that I basically said everything that I needed to say, except I wanted to just address the few issues that appellant brought up. First of all, when deciding to move, the mother filed a petition to ask for permission to relocate. And while the trial was going on, without telling either my client or the court, she moved in the middle of a trial. I think that this was deceitful behavior. It concerned the court. It greatly concerned my client. Even though the child did not necessarily move with her, she was in the position where she was attempting to provide the court with a fait accompli.
Your client was in contact with the maternal grandparent who was taking care of Junior at that time. So it wasn't like he didn't know that the mother wasn't spending time with the child during her parenting time. He knew that. In fact, he was coordinating with her.
There was no
excuse me. The mother had an opportunity for a job which was a substantial improvement in income for her and the child.
So going to answer the last question first, there was no evidence provided at trial that indicated that the mother even attempted to obtain similar employment in New York. She did not testify that she had turned down any interviews. There's no evidence that she attempted to get a similar job in New York. I agree
that she had wasn't comparable. What she was working at wasn't comparable, right?
Yeah, I can see that. Yes, what she was working at was not comparable, but there was no indication that she wasn't able to get a similar job in New York. There was no testimony that she even attempted to find a similar job in New York. And the issue about Mr. Gonzalez having contact with the grandmother, in trial, it was never determined that the grandmother had told him, my client, that the child was living with her. He was under the impression that it was the same situation because the mother also lived with the grandmother, and the father's contact, mostly in pickup and drop off, was between himself and the maternal grandmother, not himself and the mother. So for a significant—
Is it true that the court below didn't address the issue of domestic violence?
No, the court did address the issue of domestic violence, and there was significant testimony throughout the trial with regard to allegations of domestic violence. We concede that at one point there was a final order of protection against the respondent from criminal court, which was adjourned in contemplation of dismissal and subsequently dismissed, I believe, prior to the beginning of the trial. And during the trial and from the last allegation for a significant period of time, there were no allegations whatsoever of domestic violence. And the court addresses it in the decision.
And domestic violence, while certainly crucial to any analysis concerning custody of children, is not outcome determinative according to the laws of New York State. Is that correct?
Yes, and that is our argument with regard to that issue. It is a factor for the court to consider, and especially mostly in situations where there are orders of protection and orders with regard to domestic violence.
Right. We'll hear from the attorney for the child now.
Thank you.
Good afternoon, Your Honors. May it please the court, the Children's Law Center by Laura Selecki, appearing on behalf of the child. Your Honors, when I filed my brief in April, I asked this court to affirm the order below. In light of recent developments, Dr. Hertzfeld began to speak about, I'm asking now that the court remand the matter to the family court to consider developments since the close of the trial.
Wouldn't a new petition have to be brought based on change in circumstances? I mean, we're not sort of free to have rolling jurisdiction. In families, things change over time. That's the nature of families. They're dynamic. These decisions may not be enduring, but that doesn't mean that we just keep proceedings open.
I agree with that, Your Honor. I mean, we do see a lot of these issues in our cases. And on the one hand, there are appellate cases that say that the record below no longer is sufficient for this court to determine the child's best interest. And, in light of the current circumstances in facing the family court, the difficulties of filing new petitions in that court, the inconsistencies in what's considered an emergency application and when the court will hear those applications, I believe that it would be
even in light of those considerations, were we to remand it, that doesn't mean you're going to get a hearing immediately on it anyway. So I understand the problems in the family court due to the pandemic, but they don't disappear whether we remand it or you bring in a new proceeding based on change of circumstances. I don't believe that's not really a question. My question, though, to you is, where is the child now?
So that's an interesting question because he was in Texas for the 2019 to 2020 school year. That was on the father's consent after the conclusion of the hearing, but before the decision. He came back to New York with the father for the summer of 2020. He remained in New York with the father. He's attending his Texas school remotely. He went to visit the mother last week. My understanding was that was supposed to be a 1-week visit. And I just got information from the appellant's attorney that he might be there extra time at this point. So my understanding was that he is in Texas right now, although he was supposed to return from the visit to New York yesterday. And so, this issue about him attending school remotely in Texas, living in New York, I mean, there are so many changes here, but I understand Your Honor's position about a change of circumstances. So in that case, I would be asking this court to affirm. I think that if it's not inclined to remand, I think the family court did that balancing act that Your Honor referred to. It considered the fact that this was a child who spent a great deal of time throughout the week with both parents in New York, had lots of family in New York, and the mother's testimony, which frankly was conclusory on a lot of the points of relocation, was not sufficient to outweigh the benefit of spending regular, consistent time with his father and family members in New York. So if this court is not inclined to remand, I would ask that it affirm at this time. Thank you.
Thank you. All right, Mr. Hertzfeld, your rebuttal?
Yes, 2 quick issues. One is, in fact, there was testimony of appellant's efforts to find employment in New York. She was looking at civil first responders, police, fire department related jobs. She could not find anything suitable. There's also extensive testimony as to respondents' failure to meaningfully provide support for Junior, which put her in the position of living on inadequate income, public assistance in a dangerous neighborhood in a studio apartment. So with all of that and all of the factors I've detailed, even if you're balancing and including her relocation to Texas and her purported failure to advise respondent, I think the scale still tips in favor of relocation. The other thing I would point out is you've got absolutely no visitation order in place. So if you are considering remanding, that is certainly a very good reason to do so. Thank you.
Thank you all.
Thank you.
Okay, the next case for argument is Estrella versus Rex Realty.
Steve Regal for appellant.
You may proceed, Mr. Regal.
Thank you, Your Honor. Appellant is, I'd like to briefly address the two claims that we're contending were summary judgment was improperly granted in the court below. Addressing the actual notice claim and the defect being the leaking roof in the garage. The decision below, although recognizing that plaintiff testified that he was present when his boss made a call to the owner of the garage complaining about the leaking roof, the court below said that's just conjecture or speculation. And we submit that was improper.
Counsel, did the plaintiff know who was on the other end of the line?
Well, Your Honor, that's one of the points brought up. And I think he did know for a few reasons. First of all, his boss, John, told him that he had spoken to the owner and what the owner had said to him. And also, even if that were hearsay, there's corroborating evidence in the record because Mr. Kahn, who was the owner of Rex Realty, testified that he gave John, plaintiff's boss, the Rex Realty's telephone number in order to...
Of course he did. That's corroborating.
Question. Wouldn't you be able to corroborate that with an affidavit from John himself?
Well,
if he actually spoke to the landlord and said to the landlord, we have a problem with the roof, wouldn't he be the one person from whom you could get an affidavit saying, I spoke to the landlord and I told him about the roof?
Your Honor, we could have gotten such an affidavit. I don't think it's necessary. But in any case, we did not. And the other corroborating evidence, I think, is that Mr. Kahn also testified that the phone number that was given to John was only answered by himself or his son. And we think that circumstantially also goes to the fact that that the call was made to the owner. Also, we don't think Mr. Kahn's denial of such a phone call being made is dispositive. As a matter of fact, in the Dawson case in the Second Department, which was factually analogous.
Well, don't you still have the problem that the landlord is out of possession here and only on the lease obligated to make structural repairs?
That's the second claim, which I was going to address, Your Honor. But just to finish up on the first one, we believe that they're giving every reasonable inference in favor of plaintiff. There is a conflict of testimony as to this call, and it should be resolved by a trier of fact. Regarding the second, constructive knowledge of the out-of-possession landlord, the court mainly rejected it because the regulation and the incorporated property maintenance code were not those that were in effect at the time of the accident. But as we argued in our reply brief,
well, that wasn't quite the question I asked you. I asked you about the landlord's duty. He's an out-of-possession landlord with an obligation in the lease only to make structural repairs.
Well, Your Honor, actually, the court below conceded that there was in the lease, there was a right to re-enter, to inspect the premises, and to correct any repairs at tenants' expense. As a matter of fact, if you read the decision at the top of page 7, the decision says, notwithstanding that the lease did contain a right of reentry clause, which the cases we cite in our brief are sufficient to show control for purposes of this cause of action, the right to reentry to inspect.
Mr. Regal, you'll have some time on rebuttal. You've already exceeded your time. All right, let's hear from your adversary, Mr. Shapiro.
Good afternoon. May it please the court, Sim Shapiro on behalf of the defendant respondent Rex Realty. Just a couple of quick points. First of all, at the heart of this case, and one seemingly the plaintiff would like to avoid, is this the type of defect for which an out-of-possession landlord, and everybody agrees is an out-of-possession landlord, would be responsible? And this court has repeatedly held that it's not. And this is very similar to another case this court decided about 2 years ago called Mangum, which I do cite in my brief. And there it was a very similar situation where there's a leak and the claim was, I slipped on a wet floor and I claiming it's originating from a leak in the roof. And Justice Ahrens in the Supreme Court of Bronx County and then affirmed by this court, this is not the type of condition for which an out-of-possession landlord would be responsible. So if everything the plaintiff is claiming is accurate, even if they would claim, and I do agree, there's really just no corroboration, and there could have been, and counsel acknowledges there could have been, from the tenant to say this conversation actually happened with the owner and there was no corroboration. But even if it had hypothetically happened with the owner, it still goes back to, is it the owner's responsibility? And it's just not. And I'll add, if I may, if you look at page 183 of the record, the lease explicitly requires the tenant to be responsible to maintain the premises, both structural and non-structural. And it even makes specific reference to the roof and the floor and the ceiling. This is all the responsibility of the tenant. The tenant doesn't disagree. Again, it's not as if the plaintiff has offered contradictory evidence from the tenant saying, no, that's not the way it was. That's not the case at all. In fact, the plaintiff himself, who worked for the tenant, said if the floor was wet, we would clean it up. So it's clear just from the plaintiff's own conduct himself that, in fact, this was the responsibility of the landlord.
And if you're right, we don't need to reach the notice issue?
You do not. But I would add, though, even if you did reach the notice issue, the plaintiff would not be able to establish either actual or constructive notice anyway. As pointed out, there's the actual notice argument is really speculative. Well, he's got his phone number, so that's who he must have been speaking to, is simply not enough to get to a jury, especially in a case like this where the other person, this is not somebody who's a missing witness or anything like that. This is the plaintiff's boss, the tenant of the facility, for whatever their reasons were. The plaintiff did not obtain their affidavit. And in terms of constructive notice, there was actually sworn testimony from my client that he did not have any sort of notice of any kind that there was a condition going on. But again, constructive notice must be of a significant defect, okay, that violates a specific code provision. This is not the kind of condition. Again, I cited you a case, and there, of course, are others, and that case cites to others. But I cited you one, Mangum from 2018, very recent. This court has held this isn't the type of condition where you'd have constructive notice based upon the being a significant defect violating a specific code provision. Now, we haven't even gotten into the issue of the code provision. It wasn't alleged in the bill of particulars. It's improper to bring it up in opposition to a motion. The plaintiff has brought in that part of he put in a supplemental affirmation. The court granted it, and it is part of the record on appeal, so be it. The plaintiff, again, hasn't explained why it was brought up late, hasn't explained that there's actually a violation, and hasn't pointed to a single case that says the specific provision he's alleging is specific enough to constitute enough to make it constructive notice. So you really have every prong here that's missing. Not actual notice, not constructive notice, not the type of condition. In every respect, this is simply not the kind of actionable defect for which, assuming it is a defect at all, that is, for which an out-of-possession landlord would be liable. And this court has repeatedly held that way. And unless the court has any additional questions for me, I'll rely on my brief.
Any questions, colleagues? All right, we'll hear rebuttal from Mr. Regal.
Your Honor, quickly, we take the position there was no necessity to get John's affidavit, and I think an issue of fact was created as to actual notice through the plaintiff's testimony. Also, as we argue at page 9 of our reply brief, the standard for demonstrating the control of the premises is either that the landlord is contractually obligated or has a contractual right to re-enter, inspect, and make needed repairs at the tenant's expense. That's the court's case in Johnson versus Urena. It was same. So in other words, those First Department cases, we've demonstrated an issue of fact as to whether there's the requisite control for the constructive knowledge claim. Quickly, the other elements seem, there are also issues of fact, triable issues of fact raised. One of the elements of this type of claim is a significant structural defect. The fact that it's a leak in a roof that's letting water and rain to damage the interior of the building, certainly a triable issue of fact as to that has been raised. As to the violation of a specific safety provision, we refer to a provision of the Property Maintenance Code in effect that says the roof and flashing shall be sound, tight, and not have defects that admit rain, and that the roof drainage shall be adequate to prevent dampness or deterioration in the interior portion of the structure. Certainly, easily is specific provision under the court's precedents. This isn't a general, that provision that just protects the safety of the building. And the last point,
Mr. Regal, wrap it up because you have exceeded your time. I know I've been saying this a lot to everybody, but we have a very crowded calendar, so please be mindful.
I appreciate that. The last point I was going to make is that there is an issue. There's inconsistent rulings of this court as to whether a violation of the Uniform Fire Prevention and Building Code, which is a New York State regulation, can be the basis of this claim. And we assert—
We'll read your brief on that point. We have your brief on that point.
Okay, I would just add—
You are way over your time, Mr. Regal, both in your regular argument and in your rebuttal. Please be considerate of us.
Thank you, all rest on them.
Okay. The next case up is Gallegos versus Bridgeland Vestry.
Good afternoon, Your Honors.
You may proceed. 3 minutes.
Thank you. May it please the court, Dana Hines on behalf of plaintiff appellant Joaquin Gallegos. With the court's permission, I'd like to reserve a minute for rebuttal.
Okay.
Thank you. I apologize for not making
And
that
I'm
request.
going to hold you to 2 minutes, though.
Understood, Judge. Then I'll move on to my 2 points very briefly. First, even if additional discovery did bear out the version of events most favorable to defendants on this Labor Law 240 case, we still have a statutory violation because the sling in question, quote unquote, loosened, as is established in the record many times over. That is, the sling failed to provide proper protection to a person employed in work covered under the statute. Besides being properly constructed or in good working order, the law requires that the safety device is also placed and operated so as to protect workers. Clearly, the sling here wasn't, because in fact fell, injuring the plaintiff. Now, defendant's expert opinion, which purports to address all the requirements of Labor Law 240, doesn't actually say anything about proper placement of the sling. We can see this in the record at page 205, specifically paragraph 13. Now, defendant's argument in opposition in their responding papers assumes that 240 views good working order as dispositive. But the respondent's brief contains no actual authority to support this point. Our opening brief addresses this distinction at pages 28 to 29, and this court's recent decision in Ali versus Sloan Kettering, decided by a panel including Justices Gish and Mazzarelli, likewise shows that even a safety device in good working order can still fail to protect against an elevation-related risk.
Counsel, in this case, he was not refusing to use a safety device. At most, he just failed to use it properly, correct?
That's exactly correct, Your Honor. That's exactly correct. And that brings me to my second point. The defendants have failed to point to any evidence of Gallegos actually acting as the accident's sole proximate cause, nor had they even succeeded in pointing out any evidentiary basis to suggest that further discovery would lead to this evidence. And that's exactly for that reason. There is no hint of proof of an affirmative act on Gallegos' part. Now, critically, defendants had a chance to elicit this evidence before opposing motion. And in fact, they almost took it on September 30th. On September 16th. They emailed Gallegos' counsel insisting that the plaintiff's deposition proceed on September 30th. And then they subpoenaed the depositions of the 2 non-party witnesses. But instead of delaying their opposition, instead of asking for more time to oppose based on these outstanding depositions, and then presenting perhaps some kind of evidentiary basis to suggest that Gallegos was the sole proximate cause, which we dispute that they would have found, it's conceivably within their rights to look. Instead of doing so, defendants filed a deficient set of papers based on mere hope and speculation. The record contains, again, no evidence.
You're a fast talker, but
thank you, Your Honor.
You're way over your time. Go ahead.
Thank you very much.
Go ahead, Ms. Kim.
Good afternoon. May it please the court. My name is Bolan Kim, and I represent defendants Bridgeland Vestry and related construction. We respectfully request that the court affirm the Supreme Court's decision below, as there was no error by the lower court in denying plaintiff appellant's motion for summary judgment. There are 2 points that I wanted to bring up. The first is that plaintiff filed this motion before discovery was complete. There had been no depositions taken by the time that plaintiff filed.
How do you respond to your adversary's point that you had opportunities to take the deposition and you were lollygagging?
Well, Your Honor, the preliminary conference order required that plaintiff's deposition be taken on or before September 30th. The plaintiff filed the motion for summary judgment on August 29th of 2019, so almost a whole month before the deadline from the preliminary conference.
Had you arranged for a date for the deposition? I know how hard it is to find a mutual date. It would have seemed to me you would have had something on the calendar.
Right, and we were trying to confirm the September 30th date, but then
getting a deposition done by September 30th doesn't mean you hold it on September 30th.
Right.
That's the outside date, right? You know,
right. But at the
this person would have held it by August 15th, right?
Right. But at the same time, in addition to the fact that plaintiff's deposition was still outstanding by the time the motion was filed, there were 2 witnesses that plaintiff had disclosed that needed to have been deposed as well. First, he presented 2 separate statements during the course of discovery from his son-in-law.
And what did you do to get their depositions?
We served notices of subpoena to take their depositions at the time that we filed papers.
When?
I I have to look at the dates, but at the time that the motions for summary judgment were filed, we had not yet taken their depositions.
But did you need to take those witnesses' deposition before the plaintiff?
No, we don't, but at this.
Then why didn't you take the plaintiffs first?
The point here that I'm trying to raise, Your Honor, is that plaintiff filed his motion prematurely. This motion was filed before the parties had a chance to really delve into depositions meaningfully. The preliminary conference had just occurred, which required that plaintiff's deposition be taken by September 30th. Plaintiff filed his motion before then, so we were trying to get these subpoenas out and complete discovery before in a much more condensed time period. The fact is, plaintiff's motion for summary judgment was premature, and there were outstanding issues of fact here. In addition to Mr.
You've just exceeded your time. Thank you, Counselor. Ms. Heights, you have a minute. Go right ahead.
Thank you very much. My learned adversary, with all respect, has still not raised any evidentiary basis to contest any element of a 240 claim, nor any basis to suggest that Gallegos engaged in the active, intentional, affirmative choices or decision-making that would make him the accident sole proximate cause. With that in mind, I will ask to reverse the lower court and grant the plaintiff's motion for summary judgment. If there are no further questions, I'll rest on my papers.
Any further questions, colleagues? Thank you. Thank you both.
Thank you very much.
Fast talking, both of you. People versus Giles, step up, please. Mr. Bova.
Good afternoon, Matthew Bova for Mr. Giles. We raised several grounds for reversal in this case, and I'd like to focus my time here on point 2, which is the claim that the court violated the duty of neutrality. What happened here was unique and does not happen every day in our criminal courts. A witness testifies for the prosecution that he cannot identify anyone, that he was too far away from the shooting to see anyone, and that he only selected someone from a lineup because he was 14 years old and had just been shot and was frazzled and didn't understand what was going on. At that point, during that trial testimony, the court intervenes and violates the duty of neutrality. The court tells this witness, "I have concluded that you have committed perjury." I quote here from page 244 of the record, "I'm satisfied that you are not testifying truthfully."
Is that before the jury?
It is not, Judge. But that is irrelevant to our claim as to the neutrality, because the point here is not the impact that the court's conduct has on the jury. It's the specter of bias, as the Court of Appeals put it in Towns, that it created.
What did he testify to in the grand jury?
Before the grand jury, he identifies Mr. Giles as the shooter.
So he's telling the truth in one form or the other.
Yes, Your Honor, and that's the role of the jury.
And he's not telling the truth in the second form or the other.
Correct, and that's the role of the jury. The jury is supposed to be making that call. But what the court does here is intervenes, just like the court did in Towns, in order to mold the testimony to conform to his view of the case. He tells this witness, if you do not change your testimony to be consistent with your testimony before the grand jury, you will be indicted for perjury. The quote is, if you maintain the position that you have maintained, you will face the consequences that I've suggested, and the court had suggested.
He didn't conform his testimony to the grand jury testimony, though, did he? The witness? Even in the face of these, what I should call accusations or threats by the judge.
After the threats, what Rodriguez does is he acknowledges that his grand jury testimony was truthful and accurate. So he does. The court's, first of all, Your Honor, I just want to make it very clear that that's not, again, not relevant to our claim, because our point here is not that the judge succeeded in coercing Rodriguez, which he certainly did.
But he never did. Rodriguez never went back to the other testimony. He never went back to his grand jury testimony. He said he couldn't remember anything now.
But he acknowledged after the threat, what happens is, the court and the prosecutor during this colloquy.
He acknowledged that his grand jury testimony was truthful.
Yes, he did. Yes.
Yes, and he had sworn to tell the truth in front of the grand jury.
Yes, he did. Yes. And so now what the judge is, but I want to just make it very clear that it doesn't matter whether the court's coercion and threats actually are successful, because the point here is how a reasonable observer looking at this would observe.
The point here is that all that the court did in front of the jury is allow the grand jury testimony to be read, correct?
That's what ultimately happens after. Right. But
so that's what we're worried about, what the jury heard.
No, Your Honor, that's not the claim here, because what
I
we're
know that's not the claim. I know that's not what you're arguing, but isn't that the bottom line?
No, it's not, because due process is not only concerned with how the testimony comes out in front of the jury. The duty of impartiality is actually completely irrelevant to the question of what comes out in front of the jury. If a judge is violating
what's the judge supposed to do?
What the judge is supposed to do is exactly what the judge did at page 227 of the transcript before Rodriguez takes the stand. He tells the witness, I want to tell you about I want to lay out the possible consequences of perjury. That is permissible. That the Court of Appeals in People versus Shapiro has said that's fine. But then when Rodriguez takes the stand, and he testifies that he doesn't know what happened because he was too far away, the court then unilaterally stops the testimony and says, if your testimony does not change with respect to the material issues that you testified to that are so completely contradicted by your prior statements, you will be subject to a perjury indictment and an arrest and prosecution for the crime of perjury. This is exactly like Towns. Is that
a threat or a warning?
No, that is a threat, Your Honor. The warning is when a court is more than allowed to do this, is just allowed to say to a witness, you're about to testify. Perjury is a possibility that can be a charge, and I want to explain that charge to you. But here, though, the court goes way beyond that.
But how was the verdict? Effect on the witness? The witness stuck to his story.
No, Your Honor, because the witness ends up saying that his grand jury testimony is truthful. But again, that's not the claim, and I think
he has to say that, because otherwise he's going to say he committed perjury in front of the grand jury.
Well, whatever he has to say, the point is that when the court intervenes like this,
he had a lawyer, Mr. Rodriguez. The court appointed a lawyer for Mr. Rodriguez.
Yes,
correctly.
Yes, and that is another thing that a court is supposed to do. A court is allowed to tell a witness, look, I want to let you know about the consequences of perjury and talk to your lawyer. And the judge did that. But then the court comes in and says, no, I've decided myself that you're not telling the truth.
Well, let me ask you another question. Was Mr. Rodriguez the only witness?
No, he was not.
Were there more than one other eyewitnesses?
Yes, there were other eyewitnesses, yes.
So why wouldn't the harmless error doctrine apply here?
Because this is structural error, because it's judicial bias. People versus Towns, it's the same analysis. A good example would be a claim, for example, that a judge has a special relationship with the parties or has received a financial contribution. Claims that the Supreme Court
and this is comparable to that a judge is taking a bribe. You don't really mean that.
No, I don't mean it's comparable.
Okay, so let's deal with this circumstances. You feel that he was heavily weighted in favor of the prosecution's case against the witnesses that might have provided some exculpatory evidence for your client, right?
It's not just that he's heavily weighted, it's that he intervenes, just like the judge did in Towns.
Okay, I'll accept your argument that he intervened. Again, can you answer my colleague's question? Why isn't this harmless error?
Because it's structural error, immune from harmless error analysis. And that was the point I was trying to make with the analogy before, that judicial bias claims are focused on the reality that you cannot get a fair trial regardless of impact when the judge is biased against the defendant. And the question is not actual bias, the question is not effect, it's whether a reasonable observer would determine that there is a specter of bias. That's exactly what happened in Towns. In Towns, and I just want to make it very clear what that case is about, that's where the judge brokers a cooperation agreement with the witness, provides a benefit in order to secure testimony. The same thing happened here, except it's just simply the flip side. The court doesn't like what's happening, so offers a threat in order to secure the testimony that he wants. But the difference between this case and Towns, the thing that makes this case more egregious than what happened in Towns, was this is a judge making a determination about the truthfulness of trial testimony. That is not the court's function. And a reasonable observer looking on at this case, which is the analysis we have to focus on, would conclude that this judge has made a decision about who he thinks is guilty and how he wants to accomplish that. And this judge does that by threatening the witness in order to secure the testimony that he wants. So structural error on that ground.
Thank you.
Thank you.
Thank you. All right. Counselor?
Yes, thank you. Clara Salzberg for the people. May it please the court. So obviously opposing counsel and I read this transcript very differently. I believe that Judge Mendez asked, is this a threat or a warning? I read this as a warning. The judge was sort of told from the beginning by the prosecutor that there was a strong suggestion based on the conversation that the prosecutor had with this witness and with this witness's mother in the prosecutor's office beforehand, that this witness was contemplating perjury. I believe the mother said something along the lines of, tell them that you didn't see anything. And so the judge knew from that point that there might be a potential issue. And the judge responded at every point out of concern, not only for Mr. Giles, but also for Mr. Rodriguez, who at that point was, it seemed, going to commit a crime. And so, as your honors have pointed out,
notwithstanding what the judge's intentions may have been, what was the actual language that was used to convey to the witness that this was just a warning that maybe he would be subject to perjury?
So on page, it's 225, 226 of the transcript. The judge instructs Mr. Rodriguez to testify truthfully as to all events that you recall. And also says, if I determine that you're being evasive and not answering truthfully, I will hold you in civil contempt. So at that point,
does it escalate? Does that conversation start to escalate? Okay.
I don't think, no, it doesn't escalate. It evolves because Mr. Rodriguez's testimony evolves. He starts out saying he's unwilling to testify, which is why the judge is saying, I'm going to hold you in civil contempt if you don't get up there and answer questions truthfully. Then at that point, he tries to say that he didn't see anything. And that's when the judge says, okay, as your honors have pointed out, you are testifying not in the same way as your grand jury testimony, which means whether it's here or at the grand jury, you've committed perjury. So that's why the judge then says, appoints him counsel and says, if your testimony does not change, and this is on 256 of the transcript, if your testimony does not change with respect to the material issues that you that are so completely contradicted by your prior statements, you will be subject to arrest and prosecution for the crime of perjury. He doesn't say
either way. I mean, either one is true and either one is false. Either perjury before the grand jury or perjury before this jury.
Exactly. That's how I read it, Your Honor. There was never a statement, as the judge said in Towns, where also there's many different things about Towns, but one of the big important distinctions is that the judge here, when he's talking about the possibility of perjury, what he's talking about is the concern that because the two statements that he's making under oath are totally different, whichever one is the right testimony, that, he's going to be subject to perjury if they contradict each other. And so at that point, as I said about evolving, the testimony evolves again. And that's when we hear that he testified truthfully in the grand jury, but that he now recalls nothing about the events. So there's not an escalation. I don't agree with that. And I think that one of the things that the appellant is doing is the appellant is sort of
interrupt you. I'm sorry to interrupt you, but if your testimony does not change, does not that direct the witness to a particular line of testimony, just as in Towns? It doesn't say you got to pick between the two. You have. It sounds rather that he's adhering or telling the witness to adhere to what he said in the grand jury. Isn't that a fair reading of that?
I think that certainly I think that, Mr. Rodriguez had counsel, and certainly at the point where he's sitting in court, let's assume for the sake of argument that the grand jury testimony was the perjured testimony. Then yes, he's in a very bad situation because he's already committed a crime. What the judge is trying to do at this point is to make sure he understands that if he's going to testify untruthfully at this proceeding, then he will either be admitting to a crime he committed earlier, or he will be committing a crime. So, I mean, Mr. Rodriguez is in a very bad situation. The judge was looking out for his rights as well as for Mr. Giles's rights. And this is a situation where I think, any judge would be trying to balance those interests in a way that it watches out for the due process rights of all the parties. So that's really what's going on here. And you have to really read this record in a progressive way, because that's how the testimony was. It was progressive. It was evolutionary. So picking out a random snippet from one page and saying it applies to this or that, you have to read the whole thing in its entirety. And I think that when you do, you'll read it more as a warning than as a threat. With respect to Towns, I just also want to add that for the reasons that we say in our brief, that really is a completely different situation. The judge in that case was literally saying that he would impose a maximum sentence in a crime that the witness in that case was facing at that point in front of that judge if the witness did not testify consistent with what other witnesses had said. And so we talk about it in our brief, but I just want to be very clear. This is not the same situation in any respect. Unless there are further questions, I would rest on my brief for the remainder of my time.
Any questions, colleagues? We'll hear some rebuttal.
So the solution here, when a witness is going to offer testimony that is different than the grand jury testimony, is to simply tell him to tell the truth under oath. It's not, as Justice Moulton explains, as to lay out a roadmap. That's if you look at 244, lay out a roadmap for how the witness should change his testimony to avoid a perjury indictment. The record is not indicating a mere warning. That happens frequently. What the judge says here, I'm satisfied you are not testifying truthfully. An attorney will discuss with you the consequences of lying under oath, that being a perjury indictment. If you maintain the position that you have maintained, you will face the consequences that I've just suggested. That is clear and unequivocal. It is not a mere warning. And the government's position here is that every single time a witness comes into court and under oath, looking at the defendant face to face in a public trial, offers testimony that is distinct from testimony before a grand jury, the judge has the power to intervene and mold the testimony to conform to the grand jury testimony. That is not how a trial works. That's not how due process works. And that's not how the duty of impartiality is supposed to function. The judge, it's an adversary system with the defendant against the government. It's not the government plus the court against the defendant. And that obligation was violated here. Thank you.
Thank you. Thank you both. The next case is Schlamm Stone against Patricia Stern.
It's Patricia Stern for the appellant. It's versus 2C et al. Your Honor.
You may proceed.
Thank you. Good afternoon. So in this case, we believe that the lower court failed to take into account the defenses that the appellant had put forth, and that there were multiple questions of fact which precluded an award of summary judgment. In this case, the respondents had issued invoices. The appellant had repeatedly told them he was not going to pay the invoices. He had repeatedly accused them of malpractice.
Isn't this a case that turns somewhat on the timing of how things happened? Did the controversy about the malpractice and the billing occur before these particular invoices were sent and this work was done? In other words, in October.
Sorry, I didn't mean to interrupt. No, not at all. While they claim that that's the case, it's not. The negligence, the malpractice, the overbilling was found in these particular invoices that are the subject of this particular action. They're going to argue that it happened previously, and that's just not the case. On January 15th, Mr. Tucci sent an email, and I'll paraphrase, saying you've exposed yourself and your firm, you've committed malpractice, fraud, you've hired other law firms without my consent. I'll see you in court. 2 months later, they filed this action based on an account stated. This court has repeatedly held that where there's been no meeting of the minds with regard to an account stated, you can't get summary judgment. In this particular case, there was violations of the Code of Professional Responsibility. They hired an outside lawyer from California to do the bulk of the work. She billed over $60,000 on these invoices. That was over 110 hours.
Counsel, this is Justice Moulton. Didn't Mr. Tucci pay all the bills, although he insisted on a discount of some of them, through September 2018?
Yes, that's correct. But he wasn't aware of any of these things until after about October. That's when he started to suspect that there was, that work wasn't being handled appropriately.
When did he make detailed objections to the bills, do you contend?
He didn't make detailed objections, Your Honor, but I don't believe that that's necessary because in Boyes, Schiller, and Flexner, this court held that where the defendant's daughter claimed that the bills were outlandish and she was going to have them reviewed by her accountant, the court found that there was no account stated. And in Ween v. Dowd, where afterwards the defendant found that there was shoddy work and mistakes, this court also found that there couldn't be an account stated. And in Brian Salome versus Russo, the second department, where the defendant submitted handwritten statements alleging that the plaintiff had overbilled him and acted unprofessionally and unethically, were sufficient to avoid summary judgment. Remember that these bills came out and my client had not had an opportunity to review the work. So there was no way he could have known that they billed $11,000 for a motion that they never filed.
Your client had been very upset with previous lawyers who had worked for him. Wouldn't he have been on it at that point? Wouldn't he have been more assertive in looking at the bills, having been dissatisfied with so many lawyers that preceded this firm?
Well, Your Honor, that first of all is hearsay. There's no other lawyers in this case. And I'll tell you that my firm and my predecessor have represented him for over 30 years. We've never not been paid. So while the respondent claims that that's the case, there's nothing to show that that's actually the case. In addition to that, there's no way of looking at an invoice and saying, okay, I got billed for a motion. Now I have to check the court docket and see whether or not they actually filed that motion. A client shouldn't be put to that type of be required to do something that intense in order to find out whether or not they're overbilling. They shouldn't be required to find out whether an attorney is actually employed by the firm. I mean, that's something that I think goes beyond the pale, that a California attorney is doing $60,000 worth of the work that's being charged here. And by the way, that
counsel, this is Judge Mendez. Going back to what Justice Moulton said previously, this is not your client's first rodeo here. He's a very litigious individual. He's dealt with lawyers in the past. This is not the first legal bill that he gets. He knows that when he gets a bill, he goes through the bill. He goes and he checks. And so what happened here?
Well, first of all, the bills are not properly itemized. These are both billings where they put in, okay, I did 18 things on one day for a total of 5 hours. And again, a client, regardless of whether or not he's filed previous lawsuits, should not be put to the task of making sure that he's not being lied to. An attorney has an obligation to properly bill. That's why there's the rules of professional conduct. Rule of professional conduct 1.5 says a lawyer should not collect an excessive or illegal fee. An attorney is supposed to, not do that. And a client doesn't have to make sure that they're collecting an excessive fee within 30 days of receiving the invoice. That's putting much too much of a burden.
So how much time do they have in an account stated to respond to a bill? 1 month, 2 months, 3 months?
Well, I would say that that's for this court to determine. But when there's continuous representation, Your Honor, he doesn't have copies of these files. And in fact, they wouldn't return copies of the files. They put retaining liens on them. We discovered all of this by my office doing an investigation and checking the court docket and asking for copies of documents from third parties, such as other attorneys, adversaries, and other litigations. So how is a client supposed to do that? He can ask for copies of the filings, I suppose, but is that really the burden we're going to put on every client? If a client is, sorry.
I understand your argument. Let's hear from your adversary.
Thank you.
Mr. Wurtzel?
Yes, good afternoon, Your Honors. May it please the court. I'd like to pick up on something that was said before. This is a case about the timing of when objections were made and when payments were made. Let me just break down that timeline.
Well, how quickly after getting the bill must a client object in order to avoid an account stated?
Under the common law, there's First Department case law saying that 4.5 months is too much. I think I've seen case law that's even shorter. Under our retainer agreement, we say 30 days. In this particular instance, these bills were sent.
The retainer wasn't signed, but even leaving that aside, you can't rely on the retainer for an account stated. In an account stated, how much time passed between the time you sent the bills and an objection was raised, if at all?
So in this case, the bills were sent at the end of 2018 and the beginning of 2019. There were not specific objections that were raised until November of 2019, and that was in a surreply that Mr. Tusi filed months after this action had been filed. And the controlling case law holds that general, conclusory, non-specific objections under the common law, forget about what our retainer agreement says, under the common law, those types of conclusory objections, oral objections, are insufficient. They have to be written and they have to be specific. We did not get those specific objections until almost a year after most of these invoices were sent, perhaps maybe 10 months after the last ones were sent. And in particular, Mr. Tusi also said here, I couldn't make specific objections because I didn't have all the files. Your Honors, that's an admission that not only did he not make specific objections until this almost a year later, but he didn't even have specific objections to make until almost a year later. And respectfully, the controlling case law here says that is an account stated, and this cause of action is set up to allow professional service providers to not have to go through the process of proving that they did the work, that the work they did was reasonable, and so on. You have a set amount of time.
Excuse me. If Mr. Tusi had objected earlier about Miss Smithwick, or I'm not sure how to pronounce her name, the Australian lawyer who was working in California, would that be a valid complaint?
It depends what the objection was. Yes, can you hear me?
Yes.
I apologize. First of all, she was a New York lawyer. She's from Australia, but was a New York admitted attorney. If Mr. Tusi had made specific objections and said, look, you've billed me for 10 hours of Ms. Smithwick's time, and I have a problem with that for this reason and this reason, and he did that in writing, that would be a specific objection. But Your Honor, he didn't do that until almost a year later, and that's why there's an account stated here.
No, I'm asking you the hypothetical. If he did do it timely, would that be a worthy objection?
I'll answer it in two ways. One, if the objection was just, I don't like Rebecca Smithwick, I don't think that would be specific enough. If the objection was something like, she spent too much time on this one task, why did she have to research this? Why did she draft a brief that wasn't filed? That would probably be specific enough. But if the objection was just, I don't want you to use contract attorneys to do research or to do document review or things like that, that might be enough to defeat account stated. I'm not sure that would be a legitimate objection of a client, but even assuming that it was, and that would be enough to defeat an account stated, that wasn't done here, and it wasn't done for almost a year. And Your Honor, if I may just turn to the issue of the retainer agreement and our cross appeal, the lower court correctly granted summary judgment against Mr. Tusi on the account stated, but denied summary judgment on our claim for our attorney's fees and costs incurred in bringing this case. Now, as Justice Gush stated before, the retainer agreement was not signed, but under controlling First Department case law, if a client receives a retainer agreement, acts in accordance with the retainer agreement, doesn't object to the retainer agreement, but then later says, well, I'm not actually bound by it because I didn't sign it, the court will infer the client's acceptance and acceptance of the benefits of the retainer agreement as acceptance, as if the client had signed it. And in this particular case, even though Mr. Tucci didn't sign the agreement, the reason that he said he didn't sign it was because it was taking him too much time. He then accepted the benefits of the retainer agreement for an entire, almost a year, the benefits being our representation in the cases that were set forth in the retainer agreement. We billed him in accordance with the retainer agreement. He paid the bills up until the end in accordance with the retainer agreement. Thus, it was error for the lower court to say, well, I don't think you should have to pay the fees because this was a close-ish case.
I understand your argument. You're way over your time, sir. Sorry. All right, rebuttal?
Yes, thank you. So a couple of things there. With regard to the invoices themselves, you know, these cases that I've cited for the court are cases where the lower court found that the invoices had not been timely objected to. And despite that, these courts found that where they had raised fraud, mistake, or other relevant equitable claims, even in that case, that summary judgment could not be granted. Frenchman v. Gutterman, they said that it had to be reasonable if a client claimed that it was reasonable, despite the fact that he had acknowledged the invoices. In Brian Salamone, again, the court specifically said that even if the defendant failed to timely to the plaintiff's invoices, the defendant is not bound by them as account stated in the event of fraud, mistake, or other relevant equitable considerations. With regard to the retainer itself, they never abided by the retainer, not from minute one. Originally, they had one amount in there, and then they agreed to a discount. With regard to that, they also didn't disclose in their retainer that they were going to use contract attorneys, which made it deficient.
When you say they didn't abide by the retainer, you mean because they gave discounts?
Yes.
Because they gave the benefit to your client, they reduced the fee, that's not abiding by the retainer?
Let's
They
not
should have
forget.
charged them more? I don't understand the argument.
They never abided. My client also abided by the retainer until he found that there was mistakes, negligence, shoddy works. He paid them 8 months worth. He didn't pay
them if he had signed the retainer, he would have clearly agreed to it. He paid a discounted amount.
Correct. Meaning that he didn't abide by the hourly rate in the retainer, that he never agreed to it because immediately
your client never did.
With regard to the time, let's not forget that October was when the first bill went unpaid, and they filed the following March. That was 5 months worth of time. It's not like these bills sat out there for years and then they commenced this litigation.
Okay, I understand your argument. Thank you.
Okay, thank you.
Brown v. Filbert. You have 3 minutes.
Jeff Aaronwald for the appellant. Good afternoon, Your Honors. We made a number of arguments in our
Do you have some other electronic device on, Mr. Aaronwald? Because I'm getting an echo. I don't know if anybody else is.
I am also.
I have it.
You have a phone on, the app on, then your computer.
Not that I'm aware of.
Oh, much better now. Okay. Whatever you did worked.
I turned off the light.
Okay.
It was the light. In any event.
Getting more savvy with this stuff. Go ahead.
Yes, sorry.
Yeah.
We made a number of arguments in our brief. That the main argument that I'd like to focus on in my allotted time is the video footage of the accident and the minutes leading up to the accident. The motion court denied our motion, and one of the reasons the court stated it was denying the motion was that the court could not rely solely on murky, inconclusive, still video photos that do not show any water dripping from an umbrella. What the court didn't mention in its decision is anything to do with the actual video footage, or even that the court viewed the video.
Well, if it's any consolation to you, we have the video footage.
I'm glad.
We have both
because,
the stills from it and we have the video footage. Does it show water?
see, now, if you look, respectfully, if you look at the video when it starts at 3:05 p.m. And if you look at the first step down from the landing, there's nothing on that first step down. The two women walk into the vestibule, and the one woman can be seen closing her umbrella over the exact area where the plaintiff subsequently comes in minutes later and slips. Once the woman with the umbrella enters leaves the vestibule, you can now see spots on that very step, which were not there when the video starts and before the woman started closing her umbrella. And then when the plaintiff comes in and slips on that step, you can actually see those spots after she steps
Is that
on
the
it.
only time that you're claiming you can see water? In other words, you're not claiming when she opens the umbrella that you can see water coming from it. You can't.
No, but what I'm claiming is the only logical explanation for those spots to be there, which were not there before she started closing the umbrella, is that the water dripped from her umbrella. That those drops, those spots are not there at any time prior. And then when the plaintiff comes in and steps on that spot, you can actually see those spots spreading or dissipating.
Counsel, isn't it possible that water would resolve differently? So you might see some water as spots, and you might see some, or you might be unable to see other water that is on a marble step without any skid control. In other words, how do we know that the spots are the only way that water would resolve on or would show on the video?
Well, those spots are the only place she slipped. That's where she slipped. In other words, there was nothing there beforehand. And
I'm just questioning that. I don't know if we can say that from the video.
Well, I think if you look at the video, and then if you actually look at the video stills, starting at 3:05 and working your way back, you won't see those spots there until after she opens her umbrella. And even putting aside the video footage, I mean, the case law in the First Department is clear that there's no duty during a rainstorm to have an ongoing remedy.
That's outside, not inside. That's not our law. If it's raining outside, you got to do something to keep the rain from tracking you.
Well,
You put mats down, but that's a different issue. But your 3 minutes is way done, Mr. Arnold. Let's hear from your adversary.
Your Honors, it's Martin Block for the respondent. The argument that counsel for the appellant made is one he should make for a jury. That's a question of fact. The court below found that there was a material issue of fact, which was how the water got there, and it's a question that should go to the jury. And
was the video conclusive about water dropping from an umbrella?
No, it's not conclusive. It's not. The jury can see the video and make that determination. The water could have come from the people on the boots walking in and not from the umbrella. The mat wasn't there. That's a question of fact for the jury. The court was very explicit in explaining why he found the way he found. And again, he found a material issue of fact, and it's for the jury to decide. And they didn't even get to the question of the engineer, because once the court found the initial issue of fact, he stopped the analysis. He didn't have to reach the expert's opinion.
Any questions, colleagues? Okay, thank you both.
Judge, you had
Thank you, Your Honor.
You don't have any rebuttal, Mr. Arnold. I gave you more than 3 minutes that you were allotted.
May I just make one point?
No.
Thank you.
Costick versus New York State Department of Housing and Community Renewal.
Good afternoon, Your Honor. May I proceed?
You may.
Thank you. If it pleases the court, my name is Paul Gruber. I'm with Bora Goldstein. We represent Amdar Company. And we're sitting here in 2020, looking at a complaint that was filed with DHCR in 2012, which was decided based upon the absence of rent records from 1990 to 1996. Fortuitously, we do have the Regina decision, which simplifies things, and I believe that we can draw from the Regina decision 3 things that are applicable to this proceeding. One, that the agency acted improperly in asking for rent records from that 1990-1996 period, namely leases, in order to decide this rent overcharge proceeding.
Why can't we tell that from Regina? Doesn't Regina distinguish a rent overcharge complaint from the circumstances of deciding a rent-regulated status?
Not really.
Don't do that.
Not really.
They didn't. Let me be more specific.
Sure,
There's
of
a bunch
course.
of cases in front of the court at that time, and one of them was Taylor, and they specifically said, "Hey, you know, we agree, and we find that the court properly determined that in Taylor the apartment was rent regulated, even though for purposes of the overcharge, you can only go back to the base rent that was actually charged 4 years prior to the complaint being filed." Didn't they say that?
Well, I believe, I don't recall the specific with language with respect to Taylor, and I know you certainly have more familiarity with all the facts there than most people. But
Is it Diligence Taylor that I got affirmed on?
in part. The rule that they announced with respect to former Section 516G of the rent stabilization law was that it provided for a closed universe, and they carved out 2 exceptions. One, when there was a prior order of DHCR which affected the rent, and we all understand that one. And the second one was fraud. This isn't a fraud case, Your Honor. The way the Court of Appeals interpreted that old section of the law strikes me as saying that it meant what it said. The plain language should be imposed. That section appeared in the enforcement provisions of the law. It wasn't really strictly limited to rent overcharge, and I do realize this court concluded differently in Gersten. However, and we do ask that at this point we should look at it again, because then you can avoid situations like what we have right now, where 20 or 40 years from now, somebody's bringing up something that happened 20 years ago as a reason to disturb a long pattern of practice. Let's not forget here that
that's not going to happen. Well, it's going to be different in the future because now we have the new rent laws.
Well, the new rent laws pretty much allow for open-ended reviews.
That's right. So that it's only for this closed universe, this closed Regina universe, that this is going to come up.
Well, yeah, that universe hasn't really come up, hasn't really been exhausted yet.
I agree, it has not.
Now, my other point was let's not forget what happened here. This was an apartment that was subject to rent stabilization because the landlord converted a building that was commercial and got a J51. It's a post-1974 certificate of occupancy, which is very significant under the rent laws. The tenant signed 12 years worth of deregulated leases beforehand. There was an exit registration that was filed. As we show in our brief, there was a lot of delay here, and that is one of the things. And the landlord was, if it didn't maintain the records from 1990, 1996, certainly had the right to do so. But more importantly, if you look at that language, the agency had no right to ask. Now, I will make one point in the event that the court should conclude that the determination with respect to status is proper. The agency did do, when it decided the legal regulated rent, did apply a Regina-like analysis to this proceeding. If there is, in fact, and I don't think there can be a real dispute here that the Regina rule in terms of calculation of lawful regulated rent is the one that is applicable at this point. We would only ask, as we noted in our reply brief, and it was the first place where the argument became viable, that if there is a remand with respect to the rent issues, then the landlord should be able to get the vacancy allowance, not the vacancy allowance, the guideline increases that the agency deprived it of for the failure of registration. As this court has noted before, and as the Court of Appeals noted in Regina, in a J51 context, the absence of a registration shouldn't penalize the owner in that limited respect. Unless the court has any questions, I'll save anything else I have for rebuttal.
Any questions, colleagues? All right, let's hear from your adversary, Ms. Schizelman.
Good afternoon, Your Honors. May it please the court. Gentleman for New York State Division of Housing and Community Renewal. I'm grateful for the opportunity to argue remotely during this unprecedented time. The facts here are very simple. The tenant, Ms. Kostick, was rent stabilized when she commenced occupancy. She remains rent stabilized today, and in fact, she remains rent stabilized until she vacates that apartment. The law is very clear that when a building, an owner receives J51 benefits, when a is rent stabilized solely by virtue of receipt of J51 benefits, the owner has a responsibility in every single lease and renewal thereafter to provide very clear notice to the tenant in 12-point type, notifying the tenant of the existence of J51 benefits and the approximate date they expire. The owner has repeated many times here that they did provide the tenant with those notices. However,
they just didn't have them. It was over 4 years before the overcharge complaint was made that these leases existed, right?
Wrong. I'm sorry, Your Honor.
I tend to have the timing. In 1999, the landlord said J51 over. They file an exit form, right? And they register that. They file it with the DHCR. Shouldn't the tenant have objected at that time to the exit from from rent stabilization at that time? Didn't they have a viable claim at that time?
Your Honor, no, the tenant had no obligation to contest that exit registration because the tenant was never properly served with the J51 expiration riders. She was, according to the tenant and according to the administrative record, the tenant was only served with the J51 expiration notice in her initial vacancy lease. All the renewal leases that she executed subsequent to that, none of them contain the J51 rider that were supposed to be there as per the law. So the law says if the owner does not provide those J51 expiration notices / rider, the tenant remains rent stabilized for the duration of their lease. And here, the set of facts are quite interesting. If I could just go through them very quickly.
You could, but I think we're pretty familiar with. We're familiar with them. Although I will say these cases are like snowflakes. They all have their own different aspects to them. But you know, since this complaint was filed, the law has really shifted a lot, even in terms of what applies to this universe of cases that was addressed by Regina, right? Regina changed the landscape on these.
Correct. A lot of things have changed, but a lot of things have stayed the same. Regina doesn't really have a very big impact on the facts of this case because at the time DHCR decided this case, as my adversary pointed out, the Pre-Housing Stabilization Tenant Protection Act laws calculations were used. So the expanded calculations were pursuant to HISPA were not.
So how do you address your adversary's argument that even if we accept all of what you're saying, that the calculation of rent under Regina is incorrect because they didn't get all the increases that they were entitled to?
the landlord got increases that they weren't even entitled to. What the landlord did was I know you said you didn't want me to go through the facts, but if you just let me quickly go through, it's pretty egregious what went down here. So the tenant moved in 89, executed rent stabilization leases. The J51 benefits expired in 96. 3 years go by. The owner files an exit registration in 99. And what they did in that exit registration is they said it was high vacancy, high rent vacancy deregulation. They had no right to do that because you can't do that when you're receiving J51 benefits. Then they tried to change their tune and say it was a high income deregulation. Then they filed that registration and started charging the tenant a higher market rate on their own. But right after that, they applied to DHCR to deregulate, and DHCR denied them and then denied their petition for administrative review. And in spite of all that, they still kept charging the tenant this much higher market rate.
Counsel, are you arguing that that is indicia of fraud and that the agency was not rational in finding no evidence of fraud?
The agency did not properly address the issue of frauds. I'm happy you asked that, Your Honor, because upon remit, as directed by the lower court, the agency should examine and allow the tenant to prove if there's an indicia of fraud or actually a fraudulent scheme to deregulate. One might say the facts of this case could lend to that.
Anything further?
No, Your Honor. If there's nothing further, then I will rest on my papers.
Thank you. All right, Mr. Gruber, rebuttal?
Certainly. First of all, the J51 in this case expired in 1996. In 1999, under the law, the landlord, the premises, assuming the notices were given properly, the landlord could treat the apartment in accordance with the rent stabilization law, which at the time allowed for luxury deregulation. There's never been a question about the rent being in excess of the threshold in this proceeding. Secondly, the 1999 exit registration, there's nothing in the record that says why the owner waited until 1999, but the fact of the matter is the 1999 exit registration was a document filed with the agency, served on the tenant, and it certainly put the tenant on notice to the fact that the landlord believes that there was a sea change in this tenancy. That was the time to challenge. It's really not much different than a fair market rent appeal where the law gives a very limited window. I think that's 4 years under the current rules, or under the rules that were applicable before June 2019. So I think it's really not much different there. And third, the agency itself found no fraud. The tenants' attorneys' argument with respect to fraud really just boiled down to that the landlord improperly treated didn't give the riders and treated this apartment as deregulated, something for which the tenant was comfortable for very much 12 years. Now, getting back to Regina, which does have a little more import to this case than what counsel for DHCR suggests, the Court of Appeals spent a lot of time discussing the issue of fraud there, and they meant common law fraud. There really hasn't been a fact other than perhaps a mistaken treatment of the apartment based upon a document. And all the agency found here was that the documents weren't provided to it. Not that the landlord didn't do it, but that they weren't provided, and that was the sole reason they did. And as we said before, they couldn't do that, not under the plain reading of the statute as we now understand it. Unless there are any further questions, thank you very much for the time this afternoon.
Any questions, colleagues? Thank you all. Thank you both.
Thank you, Your Honors.
The next case is PBA against de Blasio. Step up, please.
Good afternoon, Your Honors. Aaron Bloom for the appellants, City of New York, NYPD.
Yeah, and Mr. Bloom, you asked for 2 and 1. You asked to split up your time.
Yes.
I'm gonna hold you to it.
Thank you. I think that should be no problem here. I just have
So the
one.
law changed, Mr. Bloom. Why are we here?
That's all I'm here to say is that that in June of this year, the New York State Legislature repealed Civil Rights Law 50A. Since Supreme Court's decision granting the petition and joining publication of the NYPD's compendium of disciplinary summaries was based solely on Civil Rights Law 50A, the decision should be reversed and the injunction should be vacated. That's all I have to say. And if Your Honors have any questions, I'm happy to discuss.
Any questions, colleagues? Mr. Bowie?
Your Honor, we don't disagree that the law has been repealed and that the injunction should be vacated. I don't think the decision should be reversed. I think it dealt with many issues, some of which weren't on appeal. But I think
what could we keep in place? I mean, there's an injunction. We have to reverse it, and the rest of it's moot, right?
Well, the injunction, the challenge that it's moot in the sense that the law has changed, but there was law below with respect to whether the PBA had stand to assert claims on behalf of its members. We don't disagree that the injunction should be vacated by this court in light of the repeal of the law, which the court is going to take judicial notice of essentially because it wasn't in the record below. We agree with that, and I don't want to get too deep into the procedural because of how to do that. Our suggestion is you simply vacate the preliminary injunction in light of the change of the law and not reverse justice.
Well, what do you do when you don't reverse? What do you do? I mean, we have to have a disposition. There's nothing to affirm. What are we doing?
Well, I think you vacate the injunction and dismiss the appeal based on the new law.
Any questions, colleagues? All right, any rebuttal, Mr. Bloom?
Yeah, just briefly, the decision on appeal is the decision granting the petition and granting a permanent injunction based solely on 50A. That decision granting the petition and granting a permanent injunction based solely on 50A needs to be vacated.
Why did we let the dicta stand? I mean, that's the question.
What did you say?
Why did we let the dicta stand? They had standing. What difference does it make? Everybody lives to fight another day on that one, right?
Correct.
Nobody's hurt, nobody's helped.
Correct. And I'd add that the standing, I believe, was decided in an earlier decision in any case, not in the one that is being discussed here.
Anything, colleagues?
No.
Thank you both.
Thank you.
Thank you, Your Honor.
Okay, the next case is Carnegie Hill versus City of New York.
Good afternoon, Your Honors. Reed Super for the appellants.
All right, Mr. Super, you may proceed.
Thank you, Your Honor. This appeal presents two main issues. First is Marx Brothers Playground dedicated municipal parkland under public park, as Supreme Court found, and public park under the zoning resolution. And second, what is the effect of that parkland status on East 96th Street project? In other words, why does it matter? Taking the first issue first, to give some examples of the extensive record evidence of parkland dedication by implication. That evidence is of, I'm sorry, Justice Moulton, are you, okay.
Yeah, I'm sorry, I was muted. Shouldn't you start with the alienation legislation in 2017?
Your Honor, I can start with that. And the alienation legislation in 2017 is one more bit of evidence that the park was parkland prior to that. But perhaps Your Honor's question goes to whether that makes the whole thing academic. Is that?
Yeah, why don't you follow that thread?
Okay, because that's what my adversaries are arguing, and it does not at all make it academic. It matters. The parkland status prior to the October 2017 state legislation matters because there is a fundamental inconsistency between what was approved by the city and what was approved by Albany at the city's request in 2017, which means that the city's two sets of approvals in that year, just 2 months apart, also conflict with each other. That is the very definition of arbitrary. It affects the legal authority of the city to approve the project. It affects the quantity of development rights available for the project. It affects the adequacy and the validity of the environmental review and disclosure under Secra and Euler, all of which were based on an erroneous position about parkland status. If I may elaborate, ECF and the developer told city decision makers and based the project on the proposition that Marx Brothers Playground is not parkland or a public park, that it could be developed and relocated without replacing parkland, and that because it was not a park, it has always had development rights that can be used for the 1.3 million square foot project. They also said that no city dollars would be spent on the project. All of that was wrong. The state legislature, at the city council's request, said it is parkland and has to be replaced with parkland. If the court would take the opportunity to compare the legislation that ECF drafted, put in the EIS, and that was considered by the city decision makers, that's at R1041, with the legislation that was actually adopted in Albany, which is at R1156, they are diametrically opposed. The city council could not approve a project premised on a diametrically opposite position from the one that the state legislature enacted at its request. That's one problem. Further, the parkland has to be replaced either on the same block or elsewhere in Manhattan. That presents a catch-22 for the project. If Marx Brothers is rededicated on the site, there would be two illegal zoning nonconformities. One is that the floor area ratio would be far over the legal limit of 12. The second is that development rights cannot be transferred to non-contiguous lots. That's if the parkland is replaced on the site. Alternatively, if the parkland is replaced elsewhere, that would be a very different project than what was proposed, reviewed, and approved. That would mean that the parkland on site would be permanently stripped of its parkland status and would have to be replaced somewhere else, nearby or elsewhere in Manhattan.
Wasn't that fact presented to the city council, that the Marx Brothers Playground, if it ever had been parkland, would not be parkland once the project went forward?
What ECF and the other proponent said was that it has never been parkland. They didn't say it might be, it might not be. They said,
but the point is that after the project went forward, whatever its status was before, it would not be parkland. So that was before the city council when they voted, wasn't it?
The city council, when they voted in August 2017, had in front of it a project where the proponent said it's not parkland, we're merely shifting it. It won't be parkland at the end. No replacement is necessary because this has never been parkland. And that proved to be false. It was parkland, and there are two places that you can replace the parkland. The legislature said the parkland has to be replaced. That can be done on site. That can be done elsewhere. That's what the city council needed to be presented with.
Was the city council aware of the 2004 temporary measure that was taken, regarding the Second Avenue subway? Was it aware of that?
Well, it was the city council. I mean, years earlier, different members of the city council, but it was the city council, as it always is, that asked the state legislature through their home rule request to adopt that legislation. That legislation referred then to Marx Brothers Playground as parkland. It said that it would be a lease from the Parks Department, not DOE, to the MTA. And Justice Kelly below pointed to that and said, at least since 2004, it must be presumed that the playground was dedicated parkland. So the city council may have been aware of that, but it was told by the proponents that this was not parkland. When the proponents said that they're going to the legislature merely out of an abundance of caution as a prophylactic measure because of somebody else's mistake, that confused the decision makers. There must have been a reason why the proponents did not propose legislation like was ultimately adopted, admitting that it was parkland and saying we want to remove the parkland status from this park. We don't have enough development rights on the block to develop this project, and we therefore want to remove the parkland designation. We want to create development rights where they do not exist, replace the park somewhere else in Manhattan. Had they told the community board, the borough president, the planning commission, the city council, but that's what they were doing, it may have been a very different result at the end of the day. What they told all the city decision makers is, this is not parkland. We have always had the development rights. And by the way,
is your position or your claim here in any way affected by the fact that the legislation itself hasn't been challenged?
The 2017 legislation?
Yes.
No.
Why not?
Well, Justice Kelly seemed to think that the state should have been joined as a defendant. I'm not sure.
And that's really why I'm asking you too, because whether you like the legislation or not, it did say, gee, it's not parkland and it's not going to be parkland in the future. And it may not have conformed to how you think the law should otherwise be with respect to changing parkland into non-parkland under the public trust. But doesn't that legislation have to be challenged? Because on its face, that's what it does.
No, respectfully, Justice Gish, the legislation doesn't say that. The legislation says that this is parkland and that the city will have permission to remove the parkland use if and only if it complies with the condition in Section 2, which 3 years in, the city has not yet complied with and shows no inclination to comply with it because it needs to replace parkland. But the legislation said it is parkland. The legislation.
So then can't you sue under the legislation? Why is it for the approval of the project at all? I just, it seems to me that there's just a piece missing here. The legislation was passed. Whatever objections you have with respect to compliance with or the defects in the legislation can't be addressed in this particular action. It stands for whatever it stands for.
Well, the condition has not been complied with. So whether we would need to file a new case, or I would suggest that it can be addressed in this case rather than a new one, because the legislation happened before the Article 78 petition was filed. It's in this record. It has a condition in it that has not been complied with. And even the respondents say that the park has not yet been alienated. The city in its brief says, we will comply with the condition, but what they propose to do to comply with it is self-evidently not compliant because it is open space that they've not committed to restoring to creating new open space. But even if they do that, it's open space, not parkland. So they have not complied with that condition. Sitting here today, it is still parkland. It has not been alienated. The condition has not been complied with. But once that legislation was enacted, in fact, once the city council in June 2017, this is 2 months before the approvals for the project, once the city council passed the home rule request, asking the state legislature to pass the legislation that referred to the park as parkland, at that point, it should not have and did not have the legal authority, we contend, to approve the project 2 months later in August 2017, because it was contradicting itself, contradicting the prior approval it had made for the project in June 2017. And Justice Gish, maybe this goes to your question a little bit. This is primarily, yes, an appeal of the decision of the city council in August 2017 to approve the project. At that point, 2 months earlier, the city council had already asked the state legislature to pass legislation saying it was parkland. And then the city went ahead in August 2017 and approved the EIS, which said exactly the opposite and had the ECF proposed legislation, which again was diametrically opposed to the actual legislation. That's what the project approved in August 2017 said. At that point, the city council should have sent the EIS back, sent the project back, and said, we just told the legislature this is parkland. And so now the analysis and the project has to be reworked in accordance with the legislation that we, the city council, just asked the legislature to adopt.
Anything further, colleagues? Okay, let's hear from the city respondent, please.
Good afternoon. May it please the court. Anna Gottlieb for the city. The project at issue in this appeal will bring new, much-needed, spacious facilities for
That's not the point. You know, I know you're going to say that, and maybe you're right, but that's not the point, okay? So let's get down to the argument here, which is, did the application for which you obtained approval, was it based on false information or false premise that this land was not parkland?
No, Your Honor, and the scope of the project is important here because I would like to note that the playground that petitioners target through their petition, it will be rebuilt to the exact same size on the exact same block. It will just merely be shifted over and it will include brand new equipment. But the playground will be the exact same size as it is today.
So it'll comply with the requirements of the 2017 legislation.
So, Your Honor, actually, the city's plan is for, if you're referring to Section 2 of the alienation legislation, the funds that have been dedicated as required in that legislation will actually be in a different part of Manhattan, which comports with the legislation. The legislation merely requires us to dedicate the same amount of funds to new parkland, and that is
so what you just told me before about the park being exactly the same and even better in a different place has nothing to do with the 2017 legislation.
I was merely explaining the scope of the project.
That it's going to be a great project. Okay. Okay. I'll accept that. And now let's talk about their objectives.
Sure. Well, our position is that this playground has never actually been dedicated parkland, but to the extent there is any question about the status of that playground today, that is rendered moot by the alienation legislation that has been enacted here. And I would like to note that the appellant did not raise any challenge to this particular legislation in their petition. So this is just a belated attempt to keep
that the legislation came after the petition, right? So it wasn't. Clearly, you're right about that.
That is not correct, Your Honor. The legislation it came before the petition, and the petition vaguely says that the city has not committed to complying, but that became clear in the record. We have an affidavit in the record from an employee of the Parks Department that speaks to exactly how the city plans to comply with Section 2 of the legislation. And so funds for the project to comply with the legislation have been earmarked. The plans are going forward. So there's no issue as to the city's compliance here. And as has been hinted by Your Honors earlier, this does not belong in this lawsuit. So the status of this playground has been rendered moot by this legislation, and it's really not an issue that is before this court.
Sorry, I am turned on. There's one difference. If it's parkland, then of course it can't be redeveloped as easily. In other words, it was represented, according to the petitioners, to the city council that this was parkland, and they approved the project, and then the city went and got the alienation legislation, or I guess the council asked for that. So essentially, it sounds like the petitioners are saying that they pulled a fast one on the city council, but that can't be the case, right? If the city council asked for the legislation.
Correct. There was, the city council put in a home rule request, and then the legislation was enacted by the state legislature, and they are independent actors. They enacted the legislation as they saw fit. And I would just like to clarify at one point whether a plot of land is dedicated parkland is actually a different question than whether something is a public park under the zoning resolution. So in theory, something could be dedicated parkland, but it might not fit the definition of a public park, which is kind of important for this project because being whether something is a public park or not determines whether that can generate floor area. So petitioners brought a separate argument that this is not a public park under the zoning resolution, and that's completely independent of the question of dedication. And really the only way a public park, a plot of land can be a public park is if it is under the exclusive control and jurisdiction of the Parks Commissioner. And completely setting dedication aside, this playground is a jointly operated playground that has always, since 1940, since it has been acquired, has been under the jurisdiction of the Department of Education. So to the extent that petitioner is still arguing that this is not a public park within the meaning of the zoning resolution, that is completely contradicted by the record. And the last point here, which was petitioner's secret challenge, again, all the agencies involved took a hard look at all of the components of the environmental review, including the open space review. And there is no question that the secret technical manual was followed, and the environmental impact statement here was specific as to the impact on open space, and that a hard look was in fact taken. If there are no further questions,
any further questions, colleagues? All right, we'll hear from the Avalon respondent at this time.
May it please the court, Philip Carmel for Avalon Bay Communities. I'd like to go back to the question posed by Justice Moulton as to whether or not the City Council was confused when the City Council voted to approve this project. There was no confusion whatsoever. It was very clear on what the City Council was doing. If we look at the ULIP application,
excuse me,
I
but
would
wasn't the
direct the
status
court's
of
attention
the
to supplemental record, page 52. It shows the zoning map as it
wasn't
existed
the
before the
status of
application.
the property misrepresented to the city council?
There were no misrepresentations with respect to the property.
Wasn't it represented as not parkland?
The record before the City Council showed that there was a disagreement about whether or not the playground was a park. The application said that it was not a park, but said that alienation legislation was required. The petitioners who are suing here had provided testimony in front of the City Planning Commission that in fact it was a park, and there was a disagreement about that issue. The point I'd like to make clear is that the City Council knew exactly what it was doing. It approved this project, taking the Marx Brothers Playground out of any potential status as a public park. If we look at the record, you see the zoning map before the City Council action and after the City Council action. That's at page 52 of the supplemental record and page 263 of the joint record. And these are the zoning maps approved by the City Council. And it's removed the words playground from the zoning map. Moreover, the zoning calculations set forth in the special permit that was approved by the City Council rely upon the entire zoning lot to generate the floor area. And those are the calculations in the approved drawings that the City Council approved. So the City Council knew that after this approval and after the state alienation legislation was enacted, this would not be a park. And the City Council thought that was a good idea, and it wanted to approve the project because it supported the project. There's nothing unlawful about that in any way. The city council has the authority.
Council, I'm sorry to interrupt you, but wouldn't you want that sort of statement of intent by the city council before you even sought the alienation legislation?
We don't need a statement of intent by the city council. The effect of the city council's actions are dictated by the
Yes, I didn't mean that in a specific.
Resolution.
I didn't mean that in a specific way. I just meant that you would want the city council to act first before you had the alienation, before you saw it and received the alienation legislation. So the state knew what the city wanted.
Absolutely correct, Your Honor. The key timing issue, there is a timing issue in this case, but it has nothing to do with the issue of the city council and the state legislation. The key timing issue is we needed the state legislation before the playground is alienated. Mr. Super, counsel for the petitioners, conceded in this argument it is not, if it was a park, or has not yet been alienated. And the city must comply with the terms of the alienation legislation before the playground is actually closed. It remains open today. Before the playground is closed and the property is deeded to the Educational Construction Fund, the city must comply with the terms of the state legislation. If the city does not do so,
so in other words, the comparable space.
That's not a lawsuit.
Yeah, but the comparable space has got to be dedicated, or the funds dedicated, before the Marx Brother Playground is closed. Is that your understanding?
That's correct. The funds must be dedicated. There must be compliance with Section 2 of the state alienation legislation before the playground is sold to the Educational Construction Fund. My understanding is the city has taken the position that it has already complied with Section 2 by dedicating the requisite funds. The petitioner seems to disagree with that. I'm not sure. None of this is actually in the petition below. This is
right. It's not part of this case.
But if the petitioner in the future thinks that the city is deeding the property to ECF without complying with Section 2, it could bring another lawsuit. There's no allegations in this Article 78 petition on that topic. This issue is not even preserved for appellate review.
Okay, thank you. All right, we'll hear rebuttal from Mr. Super.
Yes, thank you, Your Honor. Let me start with the question that Justice Moulton, I think, just asked counsel for Avalon Bay about the sequence, about having the city council act first and then the legislature act after that. That might be appropriate if the action taken by the city council first and the action taken by the legislature after matched up, if they were consistent. But because they're fundamentally inconsistent, that renders the city council's action inappropriate and ultra virus. And again, the city council acted twice, once in June and once in August. The June approval matches what the legislature did. The August one doesn't. Therefore, the August approval is the one that did not have authority to take. And there was confusion. There's a lot of difference between one position, which is this is not parkland, it won't be parkland, it doesn't have to be replaced, but just in case there's any doubt, we're gonna do a prophylactic measure, and this is absolutely parkland, and it will no longer be parkland, and it will be replaced somewhere else, maybe across the street, maybe 5 miles away. Those are very different. My second point goes to the argument by the city just now that being a public park under the zoning resolution is a different thing than being parkland under the public trust doctrine. And in theory, they could be different. I think there would be hard pressed to have a situation where something is a public park but not dedicated parkland or vice versa. Sure, it could happen. But here it was both. The zoning maps, when the project was proposed, reviewed, and approved, all showed the Marx Brothers Playground without zoning, without development rights, without a designation. That is conceded by the respondents at page 988 of the record. What they say is, in 1983, 20 or 34 years before the project approvals, there was a mistaken cleanup by some staff member, and that removed the designation from the map. But the city has to live by the official zoning maps that are available to the public. It is stopped from now saying that that was a mistake. Likewise, in 2004, when the MTA temporary approval was granted by the state at the city's request, it was the Parks Department, not DOE, that leased the playground to the MTA. DOE has never had any role. There are affidavits in the record from former Parks Commissioner Adrian Benepe. He actually named Marx Brothers Playground, and he said that DOE has never had any role, at least not for decades, in operating, managing, leasing, anything to do with the playground. And let me just close, Your Honor, by saying this would set terrible precedent throughout the city if jointly operated playgrounds are no longer considered to be parkland. In 2007, the city said that since 1938, they have been considered dedicated parkland. That restricts their use. The city created a different program called Schoolyards to Playgrounds so that it could reserve the right to take back those separate playgrounds and use them for other purposes. But the 266 roughly JOPs have always, until this case, been considered by the city and everyone else to be dedicated parkland, subject to the public trust.
Okay.
Thank you, Your
Any
Honor.
questions, colleagues? Anything further? Thank you very much, all counsel. Thank you. Okay, first Franklin Mint against Merchant. You only have the respondent on that.
Yes, Your Honor. I'll be very brief. Charles Jeanfro of McCullough Reimer on behalf of First Franklin. It's by the way, it's First Franklin Financial Corporation. I think Franklin Mint is somebody different. Anyway, I'm just going to have a couple of very brief points I want to make. First, on the issue of whether or not the court had the authority to, as the appellant raised in their brief, annul the automatic stay.
Your real point is that you want us to affirm, is that correct?
Yes, that's right.
That's sort of your overall overreaching position. Is that, do I have that right?
Yes, that's correct. And the reason is, first of all, that with respect to the automatic stay issue in the bankruptcy court, it's correct that.
Well, does it really make any difference to you why we affirm if we affirm?
No, I suppose it doesn't. I mean, I could also say that you have a good reason to affirm simply on the CPLR 5203 and the terms of the judgment of foreclosure and sale, which makes any transfer of the property ineffective as to the respondent. That would be a good reason for you to affirm. You could also find that Justice Gonzalez was correct and within her power to find that it was a fraudulent transfer under debtor-creditor law section 276, and as a result did not become a part of the appellant's bankruptcy estate, so that the automatic stay did not apply. And because the automatic stay did not, the determination of whether or not the automatic stay applied being a determination of Justice Gonzalez's own jurisdiction and not something that was within the exclusive jurisdiction of the bankruptcy court. So those are really the reasons I would have for affirmance. And with that, I'll rest on my brief unless there's other questions.
Any questions, colleagues? Thank you very much.
Thank you.
Ballard versus Sin City. Next up.
Yes, good afternoon, Your Honors. Michael O'Donnell for the appellants, the three young men, Mr. Hastings, Mr. Ballard, and Mr. Williams. This appeal is really about a precipitous and what we believe clearly erroneous order by the Supreme Court granting one defendant's motion for summary judgment and a clear failure based on the court's mysterious and gratuitous comment that the plaintiff failed to cooperate as some type of basis for an opinion, it's clear to us that the court failed entirely to bother to review a 1,900-page record, which is riddled with questions of fact. This case, unfortunately, reminds me of a case I had before this court many years ago in 1999, which I cited in my main brief, Fiorito versus Krupps, in which I approached the bench, and before I could say anything, Justice Sullivan said to me, "It's not supposed to work this way, is it, Mr. O'Donnell?" I respectfully submit to this court that in this case, it is not supposed to work this way. There are so many issues of fact in this case. I have never seen a case of similar ilk, and particularly never seen a situation where a judge would first at oral argument skip over even hearing from me, necessitating my request to make an oral argument, but then putting some type of comment in the record that the plaintiff, an unknown plaintiff, when there are three, somehow failed to cooperate. But let's look at one of the main issues in the case, and that is the issue of control over these bouncers that began an altercation with the plaintiffs inside the club and then carried it out onto the street. One thing that should dictate a reversal in this case is an express acknowledgement in writing by Sin City that it undertook to control not only the inside of the club, but the street that fronted the club to avoid police involvement. And that is expressed.
Counsel, that's in the Sin City Security Handbook, right?
Yes, it is.
And that handbook was expected to be followed by the emissary employees, correct?
It was. And
at least there's an issue of fact about that, correct?
That is correct. And that handbook specifically refers to most, quote unquote, most of the security detail being on the street until at least 4:30. And this melee, which is another word that's used in the security handbook, by intoxicated patrons, which was something that they foresaw to be a situation with this club on a repeated basis. This melee was at 4:25, when, quote unquote, most of the security detail should have been on duty in the street, helping patrons safely to their cars. Cars were parked directly in front of the club. They were parked at a parking lot to the left, and they were parked down the street. So even if we interpret most as being a majority of the security detail that night, at least there were 19 people involved in security that night, including the manager of the club, who would determine when security got to go home.
So does that all go to foreseeability, your argument on foreseeability?
Yes, that goes to foreseeability, along with a long history of complaints about this.
We're not unfamiliar with this particular location. I'm probably the only judge on this bench that served with Judge Sullivan, but I think we've all seen Sin City in various pieces of litigation over the years.
Including an appeal about their lost liquor license. Which,
I sat on that appeal, yes.
Yes, Your Honor, and well decided.
That's which side you're on, but.
So there are other issues of control of who was on security detail on this night. And the ex-police officer who was supposedly managing the security detail, in this case, said he was being paid by emissary. However, in a case that involves the same time period, he said he was never paid by emissary, and would argue with Dracopoulos, the ex-felon who was running Sin City, about getting paid directly from Sin City. So in essence, he's a special employee acting on behalf of Sin City that night. And as he admitted, standing 20 to 30 feet away from this altercation with his colleague, and did nothing despite having a 9mm weapon in his possession.
You're talking about Mr. Parker, right, Mr. O'Donnell?
Mr. Parker, correct.
Well, you're not suggesting he should have shot somebody here.
No, but I'm suggesting he had both the authority and the power and the wherewithal and the confidence to carry a weapon, and was an ex-police officer, retired, I think, after 25 years, and with his colleague could have done something. And his excuse for not doing anything was that pursuant to the handbook, before security can go home at night, they have to be released by management, which that night included Big Ed was the manager of the club. So he had to say, okay, the club's empty, or there's only a few stragglers. It's safe for security to go home. So Parker testifies that, well, he and his one colleague couldn't interfere in this melee because the rest of the security detail was still inside the club with about 300 patrons who had not, supposedly the club had not been properly closed and the people ushered outside. So he was there by himself. Anyway, so there's issues of fact about that. There's issues.
So can I ask you to wrap up your main argument, because you have far exceeded your time?
Yes. So in conclusion, Your Honors, like my case in 1999, I respectfully request that in light of the facts and in light of the lower court's abuse of discretion, that this grant of summary judgment be summarily reversed and that a new justice be assigned to this case. Thank you. Thank you.
All right, let's hear from Sin City.
Good afternoon. My name's Steve Harfinis. I represent Sin City. So the law in this case is really frames the issues, and I must have been reading a different record than Mr. O'Donnell, because I can't find any of the questions of fact that he's talking about. So let's look at the two principles of law that we have to deal with. The obligation of a liquor selling establishment to protect its patrons, and number one, and number two, the relationship between an independent contractor, security individuals, and the entity itself. So we'll start with this idea that there was some type of altercation inside of the club that spewed out into the street. The problem with that the plaintiffs have in this case is that none of them testified that happened. That not a single one of them said there was an altercation. Nothing happened. There was some.
The genesis of the dispute was about a female who worked in the club, allegedly, according to the plaintiffs. And then also, isn't there a great deal of contradictory evidence about the club's control of the streets outside of it at the time?
I don't think, Justice Mullen, I don't think there is. First off, if you look closely at the record as it relates to what happened with the girl, whether she was working there or not, there was the testimony. There was some glances. There was a little bit of what are you talking to my girl? And then everybody dissipated.
Excuse me. You're referring to the woman who was working there.
I'm sorry, yes.
Thank you.
I apologize. So the answer is that unless something happens inside the club and spills out into the street, the club doesn't have an obligation to maintain security unless they voluntarily undertook it. Now, the problem that the plaintiffs have in this case is where they testified the assault occurred. It didn't occur out in front of the club. It occurred some 25 yards away in front of a taxi stand. So even if you look at
the club maintained that taxi stand for the convenience of its guests, correct?
It was independently owned. We didn't own that taxi stand. So, I mean, well, if the club allowed the taxi stand to be there, that's one thing, but we didn't control it. It was controlled by somebody else. The video surveillance of the incident that was recovered was provided by the owners of the taxi stand. We had absolutely no control over that. We don't own that property. So the question then comes back, what's our obligation for an assault that occurs some 25 yards away from ingress and egress of the club? And we don't have any. Now, when we look back at that 2008 handbook, if you look at the actual words for it, even if it's relevant, which we don't think it is because it was before that emissary, the independent contracting security company was hired, it only talks about ingress and egress out of the club, maintaining and into the parking lot. Has nothing to do with down the street. How far down the street would we have to protect quote unquote patrons? Do we have to go to the next, do we have to cross over the street, go to the next traffic light?
Well,
I mean, the fact of the matter is
what
they
if
were
the bouncers
25
were
yards
still
away.
working? I mean, if the bouncers were still on the clock, which may be a disputed issue, I don't know. But if they were on the clock, shouldn't the club watch the bouncers and make sure they don't go and administer a beatdown to somebody outside the club?
Well, the problem is that I would agree that if bouncers left the club and committed an assault on a patron, regardless of how far away it is, it would be an obligation. It may be an obligation of the club if it's within the scope of their employment, or maybe they may have exceeded the scope of employment. That's an unrelated issue. The problem here is that the evidence doesn't support that theory. Nobody says it was a bouncer. The plaintiffs don't know who assaulted them. They couldn't identify anyone.
Didn't they describe the clothing that the people that assaulted them were wearing, and that they confronted them inside the club? And they even said that one of them was holding a T-shirt that looks similar to the ones that the bouncers wore, and came over and said, you know, you're talking to so-and-so's girl. And that's where the entire argument started. And they left, and they saw the same people that they had seen inside the club come after them and beat them down. Like,
so Justice Mendez, they testified about the testimony about the clothing is really an interesting point, because all the record evidence, other than what the plaintiffs say, is that the bouncers all wore black pants and black shirts, and these individuals were in shorts, and one was in a white T-shirt, the other one they couldn't describe who they were. So, the testimony in the record from Mr. Parker is that they didn't have any bouncers working in shorts and white T-shirts. Everybody was required to be in black pants and black shirts. There's just simply no evidence, circumstantial, direct or otherwise, that ties the individuals who had a verbal. You can't even say it's a verbal altercation. He basically said, "Stop talking to my girlfriend." That's what that's basically what they said to him. And after that, everyone went on their way. They actually stayed for a short period of time afterwards, the plaintiffs, without it. And one of them testified there was no incident, that they didn't see anything happen until they were down in front of the taxi stand. So the problem that you have is it becomes too attenuated. Otherwise, at what point, and I want to get to my line. I'm running out of my time, Justice Gisha. I'm going to get to my.
You have already exceeded your time.
I'm not very good at keeping time. So let me just make one last point. And I would point this court's attention to its decision from 2017 in McLaughlin versus B.R. Guest. And it's cited in our briefs. And that dealt with whether or not there was sufficient evidence of control to raise a question of fact of an independent contractor and a bar and a restaurant establishment where there was assault happened. And this is what this court said, and I'll finish on this note. The fact that B.R. Guest decided the number of security guards needed on a particular night and where on the premises the guards would be posted at any given time, and gave them instructions relating to the manner in which they perform their work, does not render the security guards working at the premises special.
That doesn't talk about who pays them.
Well, there's no evidence. The evidence is all sure that it's all clear about who pays them. Emissary paid all these security guards.
So if one of them testified in another proceeding about the same time that they were paid by Sin City, that can be taken into account? In terms of creating an issue of fact, you just have to accept what they say here?
I think that's, well, I guess what you're saying is, does it raise a question of credibility as to what he said in the first one? But
well, an issue of fact, I guess you could say credibility. I'd say issue of fact.
But the problem becomes is that the testimony in that prior case was not nearly as specific as the plaintiffs would like.
It doesn't really matter, though, does it? I mean, here you raised a case about control, and you mentioned everything but where they get paid from. which to me is a really significant factor in figuring out if somebody's an independent contractor or they work for you. I mean, that's sort of a key point. And if there is a dispute about that, then we go to trial.
I don't think there is a dispute about it. They're saying that Mr. Parker at one point got paid, but no one's talking about all the other security guards who are on the premises. That everybody was paid. All this.
But what is Mr. Parker's relationship to emissary? Isn't he the so-called principal?
No, he's the principal of emissary.
Right. Okay. All right.
So the fact that he had been working, the fact that he might have been, and I don't know enough about the other case, that he might have been working at that point as an employee doesn't mean that he wasn't working as an independent contractor at this time. That doesn't raise a question.
Okay. All right. Thank you.
Sure.
All right. Let's hear from emissary.
This is Sean Callahan for emissary. We have to be super careful here, guys, because this is, Your Honor, this is not an issue of control. I said, I apologize, Your Honor. You have to be very careful here. This isn't an issue of control because what we're doing here is we're assuming that.
Let me ask you more fundamental.
Go ahead.
You didn't move for summary judgment, so what are you doing here?
Because I can get out.
You have a right to be here.
I absolutely have a right to be here under 3212B because he brought the same causes of action against us as he did against Sin City.
Don't you have to move?
No, don't.
Oh, no. All right. You ride their coattails. Because they control you? I don't know. You have a compatibility of interest? I don't know.
The case law has shown, the case law is clear that when the causes of action against both parties are the same, a non-movement can benefit from summary judgment by the moving party. I mean, it's a matter of judicial economy. And the lower court is free to review the record to make sure that works. And here that happened. So we need to be clear, though, because we're assuming that these bouncers were involved in some sort of assault. But let's understand, each one of these plaintiffs told a different story. Look at James Williams. He said that the Hispanic male that assaulted him, he described him as short and stocky. His friend described him as tall and skinny. One said he was bald. The other one said he had hair, had dark shorts on. Look at the video. The video is not their friend. In this instance, there was not one individual in that video with dark shorts on.
You know, it's to me, it's quite a reasonable possibility that when you're being slashed and beaten up, you might not be able to completely remember all of the clothing of the people that are beating you up and slashing you. So you might say that they're long pants or short pants, they're all black pants at least. To me, those are issues of fact.
Your Honor, I mean, these people were deposed 2 times, and one of the individuals on his own went to the police, made a statement that they were actually sitting next to 3 Hispanic males and 2 girls, and the other plaintiff.
2 women. Let's call them women, huh?
Well, I'm just saying that's what he referred to him in his deposition. Now, the other plaintiff, having the opportunity to respond to his deposition, said his friend was a diminished intellectual capacity, not the sharpest tool. That's how they try to put distance between a statement to the police and their inconsistent deposition testimony. There's no issue of fact here. There's no way you can connect the bouncers to the assault, because here we don't have to rely on someone's memory. We have a video, and the video doesn't support any of their testimony.
Okay, thank you, Mr. Callahan. Let's hear from Mr. O'Donnell rebuttal.
Yes, we are looking at 2 different records, except I think I'm actually reading and citing the facts of the record instead of some fanciful interpretation of the record. There was indeed violence inside the club. It was the bouncer with his girlfriend. Williams described him as coming in and yoking her up, something to that effect, and dragging her away from the conversation, saying, "This is my girl." We don't have to be grow up in a different environment to know that this type of action, coupled with Mr. Ballard hearing the dreadlock bouncer saying, and I can't say the N-word, but this N-word is not leaving with that girl and then sending his colleague bouncer out to get the other bouncer whose girl it was. If that is not negligent security, I don't know what is. And these defendants have consistently offered in the disguise of some other record of promoting a false narrative that nothing happened inside the club, that the bouncers didn't go after them, chasing them out of the club, advancing the altercation by saying, you N-words are fronting, which means you shouldn't be here. You're inferior. You shouldn't be with our girls. You shouldn't be in this club. And then following them out onto the street. And then Mr. Ballard saying that the dreadlock bouncer was the first to throw a punch. So yes, we're looking at two different records. I'm looking at reality, the record as it exists. And this defendant who made this motion, these are all attorneys who came to this case late. They were not present at the depositions, right? So when they made the summary judgment motion, they did not even include the second day of deposition. So to say that this record is somehow being falsely represented by the plaintiffs is sheer pap. It's misrepresentation. It's the same type of misrepresentation that was made in this appeal. One, that we'd never asked for the videos in a discovery request. I asked the court to look at the record in the lower court, which I pointed out in my brief. There are multiple requests for any videos by the club, which were in fact spoliated, which is another issue of fact that has to be dealt with at trial, whether or not the spoliation was reasonable or not. Then look at Dracopoulos'.
I'm going to ask you to come to a conclusion.
So spoliation, Dracopoulos' own felony record, his inconsistencies at best in his testimony, along with Parker's inconsistencies. This record cannot, advanced by the defendants, cannot even be considered by the court because we're entitled to a falsus in uno, falsus in toto charge at trial. So I'd ask that again.
That doesn't defeat. Oh, sorry. Never mind. I withdraw that. Okay. Thank you. Thank you all.
Thank you.
Okay. The next case is DJR Communications against 530 Park Residential Holding.
Yes. Good afternoon, Your Honors. May it please the court. Kevin Schlosser for the appellant. In this appeal, there are two basic issues. One is whether an entirely new separate corporation, which we call First DJR, which was not part of the case, can be added to the case after 6 years of litigation and directly against the affirmative allegations of the existing complaint. And we naturally maintain that that was an error, and that ends the case right there. The second issue.
Well, even if they're not added, the relief here, which is that there was a lease with the first corp, with the corp, I forget, without the dot, with the dot, whatever, that the rights derived under that lease, and I'm not sure that it really matters if you add the new corporation in or not. Why does it matter for the relief that's granted?
Excellent question. So it absolutely matters because these are two distinct entities. And second DJR, which was only created as a result of first DJR being dissolved. And on the exact...
It was reinstated. They paid the franchise taxes and it was reinstated. You knew that. Excuse me, let me finish.
Sorry.
That is stipulation. We acknowledge that it was reinstated.
Okay. Judge Moulton, would you like to add or before
You don't want to answer my question?
Yes, I would.
Let's answer Judge Gish's question, please.
Sure.
Thank you. Thank you, Judge Moulton.
So as far as the reinstatement didn't come until after this case was started. So when this case was started, and this is very important because it's critical, the plaintiffs in the case affirmatively took the position that it was the second DJR that was the tenant, not the one that was dissolved. And we know why they did that, because they couldn't bring the case on behalf of a dissolved entity. So what they did was they affirmatively alleged that second DJR was the tenant under this lease. And there's no evidence whatsoever that second DJR was ever offered that lease or was ever even contemplated to be a tenant under that lease. So after the case has started, for 6 years, they litigate this case, affirmatively alleging that second DJR is the tenant. Even after first DJR was reinstated in February of 2013, year after year goes by, and they affirmatively still maintain that it's second DJR that is the tenant. And that creates the prejudice and the harm here, because I have a right to know, as I'm facing a case, what does the complaint say against me? I'm supposed to be put on notice. Then I have an opportunity to defend the allegations of the only complaint against me. And here, the defense is...
Your defense was, gee, I never had a lease with second DJR. I had a lease with first DJR. Right?
No, see, that's the subtlety.
You didn't have a lease?
That's the subtlety of the case. You see, the respondent wants you to believe that we were saying all the time, it's not second DJR, we properly had a lease with first DJR, okay? That's not what we maintained in this case.
Who would you have a lease with?
No one, because it was a dissolved entity. It shouldn't be granted the right to a lease. You see, you may say, okay, it was a dissolved entity when it was presented to us. The landlord did not know that it was dissolved. It was duped into giving a lease to an entity that it didn't need to.
Counsel, in the non-payment proceeding, didn't you acknowledge that DJR Dot was indeed the tenant?
We had no idea that the second DJR was even created at that point. That was part of the deception here. It was part of the scheme that went on, okay? We didn't know. And frankly, this is not something that we affirmatively did wrong, or we affirmatively conducted ourselves in an improper manner. We were facing a case that said a different party was the tenant to the lease. We had a right to defend the case along those lines. For 6 years, all right, we thought we were litigating a case that was brought by plaintiffs who have no standing. At the 11th hour, after the case is in, the trial starts, in a discussion of housekeeping, when we inform the judge, well, we have to change the name of the respondent defendant because its name changed. Then plaintiff's attorney says, oh, by the way, in the same discussion of housekeeping, I think we should add first DJR, as though it was simply a matter of clarity. It's not a matter of clarity. It's a matter of substance. That entity is a separate legal entity. It cannot be considered, as this judge found, quote, one and the same. That's as a matter of basic corporate law.
But they moved for that relief. Counsel, I'm sorry.
Go ahead, Judge.
Well, I was just going to say that, counsel, they moved for that relief prior to the trial beginning, and then the trial judge said, you know, I'll take it under advisement, and then he conformed the proof to the pleadings to the proof. Isn't that perfectly kosher?
No, it's absolutely not kosher as to what was done here. In one paragraph of his decision, he addresses this amendment. He doesn't address CPL Law 3025B or 3025C. 3025B specifically requires a formal motion, a proposed pleading, and it gives the defendant an opportunity to know what the case is about, to respond to that, and to adhere to it in its defense. In addition, if you're looking at 3025C, which is to conform the evidence to the proof, this court has held, and it's a very enlightening case, Bargani versus Friedlander, 197 AD 2nd 281. It specifically says The 3025C is designed to afford a party to respond to the evidence as it unfolds at trial. It's not designed to give a party the opportunity to assert a new theory of the case to respond to defenses that have been asserted. And that's exactly what was going on here.
Okay, I think we understand your arguments. Thank you. Mr. Olch, did I pronounce that right?
Yes, you did. Thank you, Your Honor. The question before the court is whether the lower court abused its discretion in permitting that the party be added at the end. The question is, the standard of review is deferential. And basically what counsel is asking, or appellant's counsel is asking, is for this court to ignore the New York Court of Appeals Kismo decision, as he does ignore in his current argument. Basically what Kismo says is a number of things, but what it says here is that if a party presents at trial evidence or puts before a court its own evidence, and then its adversary uses the evidence that's been presented to move to amend the complaint, that is basically permissible. And
so
in
let
this
me ask you a question, though. We're not talking about, gee, we made a mistake in how the corporation is named. These were two distinct corporations, right?
The two distinct corporations, but the notion that suddenly 6 years later, DJR dot emerged is not so, because if you look at the verified answer filed in 2012, and you look at the counterclaims alleged by the landlord, all the counterclaims allege DJR.com, that they were involved in this, that somehow they somehow cheated somebody, that they've been dissolved, etc. DJR dot did not arise suddenly 6 years later. It was part and parcel done 6 years before in their counterclaims. So there's no surprise here.
In the non-payment proceeding, who did they sue?
They sued DOT. They sued DJR.
They sued the first corporation, right?
That's correct. And
they accepted all the money from the first corporation.
In the record, there are two checks totaling $54,000 drawn on DOT. And the reason why they sued DOT is because all of their records showed that DOT was the tenant. And what the appellant wishes the court to overlook is that all of this started a year before the lease. DOT was not a stranger, wasn't someone who walked in off the street to sign a lease. He was on the 17th floor of the building, and he and the landlord made an agreement they would move down to the third floor. And there's a relocation agreement in the record at beginning at page 290, in which the landlord agrees that
but I understand, everybody understands the history here, but there was a time where the first corporation was dissolved for non-payment of franchise fees and taxes.
That is correct. And
I suppose the accusation that they're really making here is that what your client did is form the second corporation in order to have to avoid paying those franchise fees.
Well,
that wasn't right.
Well, we don't know, well, two things. One, we don't know why he formed the second corporation, but that relocation agreement I just alluded to was entered into 1 year before, actually 13 months before this second corporation, the No Dot, was created. So it had nothing to do with the incentive behind the relationship between the parties. Secondly, counsel in his appellant's brief, as well as in his respondent's brief, doesn't come to grip with tax law section 203 and does not come to grips with this court's decision in the prop case, which I cite in my brief at page 28. In the prop case, it was basically the same situation. A company is a tenant. They don't pay their franchise tax. They're dissolved by the state tax office. They then reinstate their franchise tax. And the question is the lease that they signed during the time they were dissolved effective? And the answer that this court gave is yes, it's retroactively validated once you pay your franchise tax. And basically what the appellant is seeking to do is to run away from that by yelling fraud, et cetera, et cetera. There's no fraud. The fact that
even if your purpose was not to pay franchise tax, it wasn't really a defraud against the landlord.
No, the landlord has not been induced to do anything because there was a second corporation that was formed that day. They, as I said, they created this whole relationship a year, 13 months beforehand. They entered into the agreement to get DJR Dot to move down to the third floor because they were converting this into condominiums. And in fact, in the landlord's representations to the Attorney General's office, when they were doing this conversion, they had to put down who was the tenant of apartment 3G, and they put down DJR Dot. So this whole notion that somehow they've been fooled, they've been misled, etc., I think Your Honor is exactly correct, that this other corporation had absolutely nothing to do with the validity of the lease between DJR Dot and DJR and the landlord. Yes,
Okay,
Your Honor?
thank you. No, your time is up.
Oh, no, I thought.
It seems to me my
was about to
refrain
ask a question.
today.
I'm sorry.
No.
Okay.
No, okay.
All right, some rebuttal.
Yes, very quickly. Kismo. Okay, Kismo doesn't apply. The distinction of Kismo is that the party there was affirmatively alleging something that was then used against it at the trial. And the court said they haven't been prejudiced because they're the ones that alleged the settlement agreement on which the other party's claim was based. We were not doing that here. We didn't assert at trial that second DJR, that first DJR was a proper tenant. We never alleged that. We were alleging.
You did allege that the second DJR was not.
Excuse me, we didn't allege that first DJR was.
I know, I'm asking you a different question.
No.
Did you deny that that second DJR was a proper tenant? It was not a defense, no?
We alleged neither one was a proper tenant. Second DJR, we denied that throughout, and we didn't admit, nor did we assert that first DJR had the right. So that distinguishes Kismo. 2, this non-payment proceeding. We instituted the proceeding after the proceeding was instituted. This case was brought. So when this case was brought, we stipulated in that to accept rent under full reservation of rights to make the arguments we were making in this case. So that does not represent
on them.
That does not represent an admission. Okay, it doesn't represent an admission. And the other statement that the respondent has made is we don't know why the second corporation was created. I mean, that just doesn't make any sense.
But even if we did, all you can say is that they were trying to get out of paying taxes to the state. How does that hurt the landlord?
No, they were trying to.
Other than in the sense that they are, citizens of the state.
Excuse me, I'm sorry. Because if the landlord knew at the time that an entity that was seeking a lease was dissolved and had no legal right to enter into that lease, it would not have entered into that lease. That's how the landlord was prejudiced by that.
Well, they couldn't assert that as a defense against you if you brought an action against them. Only they couldn't bring a suit.
No, right? But they didn't have the right to enter into the contract because they were dissolved.
But it's valid as to your client. In other words, your client could take the rights under that, even though the corporation had been dissolved. They couldn't get out of their obligations to you because of the dissolution. Right? That's right.
If that's correct, but the point is that the landlord had the right to decline to offer the contract to a party who was dissolved.
All right, I think we understand. Any further questions, colleagues? Okay, thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, Ferrugia against 1440 Broadway.
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff appellant. And Judge Gish, I'm going to actually try to stay under my time.
I know you will. I know you will. You're good like that. Go ahead.
So my argument is very simple. Let me make the concessions that I need to make, give you my argument, answer any questions, and stop talking. Mr. Tagliagambi won the trial. He had a grand slam. He did a great job. I'm a non-prevailing party. Juries have a right to decide contested issues of fact. My argument is very, very razor sharp. As I read the testimony of his witnesses, they said that the plaintiff either didn't have an injury or had mild sprains and strains that would resolve from 2 to 8 weeks. My doctors, treating physician, said the plaintiff had a major ankle injury, had surgery, needed a Bostrom procedure, had an osteochondrial lesion. He's going to be in pain the rest of his life, and he has a back injury that has serious limitations of motion. The fact is that the jury's award of $400,000 for past lost wages is just not consistent with any of that at all. If the plaintiff had a strain, if it was supposed to resolve within 2 to 8 weeks, that award can't make any sense, nor can the $50,000 past pain and suffering award for
So,
7
counsel, does it matter? I mean, Dr. McMahon and Dr. Tuliopoulos, they were your experts.
Correct.
They admitted that they hadn't seen the 2007 MRIs. Isn't that correct?
They did.
And so couldn't the jury reject the plaintiff's experts for forming opinions without complete records? I mean, so they reject those. And then you're saying even so, the verdict makes no sense?
Absolutely. If the jury had awarded a minimal amount on the past wages, I'm not here. And I would also point out, Your Honor, if I can, there is one undisputed fact that my adversary didn't talk about. It's really, really important, and I just want to raise it to you. My client, prior to this accident, okay, I'm not talking about after the accident. Mr. Tagliagami did a great job talking about colorization, lack of injuries, etc. But prior to the accident, my client was a gigantic worker. 2,200 to 2,300 hours every year, 30 years old, level 10 pension. That is appellate division judge hour. Those are lawyers' hours, and that is undisputed. So the fact that he suddenly decided that he didn't want to work afterward doesn't make a lot of sense to me. But it's the award that I'm challenging. I'm not fighting at all with the jury's right to make those determinations. I'm on record as saying they have that right. I'm not retreating from that. But this particular finding just doesn't make any sense in the context of this record, where you have two diametrically opposite positions. Plaintiff saying I have a horrible injury that's worth multi-million dollars, and defendant saying you've got a sprain. It can't stand. And while I did waive any claim of inconsistency on the Griesiak and Barry, the fact is, on the Califano case and the Ramos case, I don't waive claims of excessiveness or inadequacy, nor do I waive claims that the verdict's against the credible weight of the evidence. So I would argue that this award has to be set aside. 15 more seconds, and I'll sit down. I do have to concede to you that there is a possibility that this was a compromised verdict, page 47 of my brief. Although I tried to find cases against it, I couldn't. If it's a compromised verdict, I think I lose the liability verdict. And I think the compromise comes in based on the fact that my client had two physical conditions that were unusual. First, he had a sacralized spine, and he also had an os trigunum, which is a bone in the back of the foot. It didn't seem to stop him before, but if in fact the jury felt that that was a condition that shouldn't have resulted in a recovery, and they decided to give an award of earnings while minimizing plaintiff's injuries, I think everything has to come back. Last point, Tobin against Steisel, an act which causes, which activates a latent condition or aggravates a pre-existing condition is a legal cause of that injury. And if you have nothing further, I'll rest on my brief. Thanks for listening.
Any questions, colleagues? Mr. Tagliagami, you may proceed.
Tony,
I can hear you. Unmute yourself. Try again. Go on. Well,
is that better?
yes.
Your Honor, thank you, Mr. Isaac, for your compliments. As you started out today, you said that these cases are a balancing act, and maybe this verdict is a reflection of a balancing act. I think there was very significant evidence for the jury to accept the opinions of the defense experts, and I think the record is laden with inconsistencies with the approach of the plaintiffs, treating doctors and experts. So were there mistakes made? I tried the case, and I would say, yeah, I made my share of mistakes, and plaintiff's counsel made his share of mistakes. But was there anything that constitutes reversible error? There is no preservation of the missing witness charge. Just dealing with Mr. Isaac's argument, and I think he's narrowing it down to that issue. The jury awarded $400,000 for past loss of earnings. The accident occurred on February 4th of 2012. The verdict came down in April of 2019. The plaintiff was making, when benefits are attached to his salary, he was making somewhere in the vicinity of $150,000 per year when benefits are factored in. So if you look at the time that they awarded earnings, it was not over the period of time from date of accident to date of verdict. They approximated maybe 3 years. In that intervening time, plaintiff did have 2 surgeries. So I think the jury may have felt a little bit of sympathy for Mr. Ferrugia, but they clearly did not award him loss of earnings over the entirety of the time between the verdict and the date of the accident. So as Mr. Isaac has argued very well in many cases, the jury is entitled to reject expert opinions on one side, as they did in this case. And there was ample evidence, as cited in our brief, to support the findings of Dr. Eisenstadt, Dr. Bezos, Dr. Garay, with respect to what they perceived to be a relatively minor injury superimposed on pre-existing conditions that plaintiff's doctors did not even consider in their evaluations, which I think clearly impacted their credibility. They produced a vocational expert who said that this person was incapable of doing anything, when we know factually he worked for about 10 months post-accident doing used car salesman activities. So I think the verdict was appropriate. I don't think there's any reversible error. I think it was a sound verdict, and I'm willing to answer any questions that the court may have.
Any questions, colleagues? Thank you.
Thank you for your time.
Yeah.
Yes,
you 2 minutes.
It'll be under 2 minutes, just like it was under 5. Plaintiff's total past economic loss to earnings 456,185, 647 to 648 of the record. Mr. Tagliagambi's witnesses 840 to 841, 899 to 900 and 908 said this was a sprain that would resolve in either 2 weeks or 6 to 8 weeks. Nothing that my adversary changes what I said. This is a case.
Can I ask you a question, though? Do you agree with the analysis that the 400,000 represented about 3 years of lost earnings?
I do not, and that's why I gave you that reference, Judge Gish. Our expert calculated total past lost earnings. He was the only expert to testify. 456,185, 647 to 648 of the record.
And that was to cover what period? When did he testify, or when was his report? From 2000?
Yeah, it was past lost earnings. That was his total computation when he testified. That's Leonard Freifelder, our economist.
So from the date of the injury until the date he testified?
That's my understanding. Yes, Your Honor. So it's a 50,000, and that's what we argued in the brief. It's a 56,185 dollar discount, which would be inconsistent with a sprain anyway, where the sprain was supposed to last 8 weeks. So that's the point. And if you have nothing else, I'm happy to rest on my brief. Thanks for listening to me.
Anything, colleagues? All right. I thank you all. I thank you for your patience in the last case on a very long calendar. The session of the Appellate Division is now closed.
Keep well.